I got it correctly.
Okay.
They're marked as defense, F, this is in the public records. This is the second mortgage of the property in this case. This is reported.
No objection. Just the relevance.
You'll tell me why it's relevant or not. I'll receive it in evidence without objection as 22, defense 22.
We have defense exhibit GD, the letter from the law firm
Hearsay.
to Ms. Atwell, Mr. Bennett, terminating Mrs. Sahm, terminating or attempting, I should say, to terminate Amber Patwell August 1st, 2023. And the attorney is present here for the is Mr. Rivard present?
Right.
Is Mr. Rivard present?
He's not present here now.
Is he on Zoom?
I haven't looked. Is the phone on Zoom? Anyone?
Sure. Ms. Garcia?
I would move it in, and Your Honor, not for the truth of the matter asserted, the fact that this letter was sent.
It does appear to be words of operative legal effect seeking to terminate an attorney-client relationship, so I'm going to receive it over objection as defense exhibit 24,
23. The next one is defense exhibit HH, which is filing, which is related to, for the record in the estate case of Walter Sahm. This is the statement warning creditors.
What else handwritten?
And the handwriting is my notes, which I will testify to those notes as far as, that was for my conversations with Mr. Raymond when we were settling the case. We were going over the estate's rights. I'll testify to the relevance of it during my testimony.
First of all, number 3 says there's something attached, list of creditors. And I don't see anything attached to this. Second of all, I don't see how this is relevant. The estate has no claim in this case. The estate has never had a claim in this case.
In an abundance of caution over your objection, I'm going to receive it in evidence as defense exhibit 4.
Your Honor. It's a, Ms. Patwell's response to the guardian's request for adoption that was delivered in the guardianship case.
No, this wasn't filed with the court, and it's hearsay.
These are all the documents that they requested to be produced by Ms. Patwell. And this goes to the mental impressions of her and I's negotiations and what she produced to the court. It's very relevant to the issues of fact as far as communications by Ms. Patwell. It's got the mental impressions that Judge Burton had read into the court.
I have a right to cross-examine Ms. Patwell about her writings and mental impressions and everything else. That's why we have a hearsay rule.
I mean, this does appear to be classical hearsay. So at this time, I'm going to sustain the objection on a hearsay basis. Subject to you seeking to admit it some other way. But it's hearsay right now. For identification only.
This is JJ, Your Honor. This is the
No objection.
this actually would probably really tie in.
Doesn't sound like there's an objection, so what is it?
Okay. This is the actual executed stipulation of constitutional counsel, where I had already moved into evidence the one time by the Church province with a fully executed file stipulation, and it also has the proof of the delivery.
And the order.
Yeah, and then the order substituting Ms. Patwell in as the attorney for Ms. Sahm.
Will be received into evidence as Defense Exhibit 24, 25.
Of Defendant's Exhibit KK, which is Mrs. Patwell's agreement. This is executed by Ms. Patwell. The Sahm dated May 1st, 2023, been provided to the court in the mental health case through discovery, and it is an exception to the hearsay rule.
You've already determined that retainer agreement's an exception.
We're received into evidence. Is there an objection?
Pardon?
Is there an objection?
I'll object to hearsay.
We're received into evidence over objection.
I think correctly made
That's 26. Well,
make a record. But,
just ask.
I don't think I go any further than that.
Just ask.
I think we've already moved the settlement agreement, fully executed settlement agreement in, let me see something.
Did you put X?
E. No,
I have it as
I think it's Exhibit 6, Defense Exhibit 6.
yes. I have it as Exhibit 6 entered in on August 12th.
Okay. I don't know if you need a copy. Do you have a copy from last time?
Which date? Which one is this? May or?
The May 22nd agreement.
Okay.
So it's already in there.
And then you had a copy of the prior agreement signed by your clients.
Yeah, I'm not using it.
Okay, well, I want your own. She produced at a deposition a document that I put into evidence that she stipulated to. She did not give me the copy that was signed by her. her client signed a settlement agreement referencing Mrs. Sahm was incapacitated repeatedly. So I do ask that she produce here the complete document, not the one she gave me at the deposition.
Do you have that document,
Ms. Garcia?
Ms. Garcia? Do you have that document, Ms. Garcia?
No, I don't intend on using it.
Right, but wasn't it ordered to be turned over, and it wasn't turned over, so shouldn't it have been turned over?
No, it was turned over.
Not with the
And the
signatures,
depositions.
not with the signatures. I put in evidence what I've been given by her. I don't have signatures.
Do you have one with the signatures?
Yeah.
Well, I said
It's
I want it.
marked as Exhibit X.
You don't have to enter it as evidence, but
I,
he's entitled to it, and he may want me to receive it as the evidence. Sounds like he does. So
I'm gonna substitute this, and when I was presented with this, I said I want to substitute this for what's in evidence. I did not object to hearsay. So this is a settlement agreement signed by the Bernstein side on March 11th, and it is being substituted. Or it can be an addition.
Ms. Garcia, what's your position with respect to, I guess, do you have the same position that you did when they moved plaintiffs 5?
I'm sorry, Your Honor?
Do you have the same position that you did when they moved plaintiff's exhibit number 5 into evidence? Or any additional?
You see, plaintiff's 5 was not accepted. I don't see it anywhere. There is no plaintiff's 5. So,
Madam Clerk's indicating it was received without objection. You have the date at 11:09 today. I know we've been working hard, but apparently it was submitted at 11:10.
I'm sorry?
I have, this is, yes, sorry, right here. Yeah, it's this one. This is how it starts.
Yes, that's a transmission.
So, do you have any additional objections to this signed?
No, Your Honor. So what numbers did I apologize. I lost.
I'm not gonna substitute it, I'm gonna receive it in evidence as, what's plaintiff up to? Well, I'm gonna receive this one, the signed one, as plaintiff's exhibit number 12.
Is there an ID number or just Exhibit 12?
Exhibit number 12. ID 12, exhibit 12.
Thank you, Your Honor. What was plaintiff's 11? I don't see an 11. I have that as 10. 5, 6, 7, 8, 9, 10.
10 was another order.
An order appointing a limited guardian is 9, and an order granting. It was the objection, right, to the examination committee? 9 is the notice of appearance, and 10 is the order, 11 and 12. Okay.
Clerk, you don't have to call it, you're fine.
Thank you, Your Honor.
Yes, ma'am?
Your Honor, I do have the Sunbiz report that I've been 13.
All right.
Council wants to take a look at it. Are you finished?
No,
I'll let you finish.
no, 2 more. Okay. Let me bring up this one. And then,
Are you giving her these messages?
wait, I'm sorry. First order, I could put it in the right order for you. He's one in the right order.
Good.
Okay, this is MS MM
Wait, one,
for
two,
identification.
stop and start your recording.
Me and Mrs. Atwell. The relevant time frame. May 1st, 2023, through May 22nd, 2023.
Check the hearsay and anything that Ms. Garcia wrote, she can certainly authenticate and testify to in court.
All right. Ms. Garcia?
I guess the same objections last time. This is a business record. This is, my statements.
Start a new recording.
Also, business record. And it's a statement of previously existing state of mind.
I'm gonna sustain the objection, as to hearsay. Those will be marked for identification purposes as MM.
That's it for now, Your Honor.
And Your Honor, Ms. Garcia, you want to take a look at this? I do have the current Sundays filing showing dissolution as of September 27, 2024.
Do you have a copy for me?
I only printed it out.
Okay, so this is,
Plaintiff's 13. Any issues with plaintiff's 13?
no, Your Honor.
Proceed by stipulation of parties, plaintiff's agreed on 15.
Why not sitting next to either?
Thank you for your patience, Your Honor.
Do you have additional documents that you need to admit?
I'm sorry?
Do you have any additional documents that you need to admit?
Not at the moment, no, Your Honor.
So we have your witness that's.
Yeah, we're discussing whether we can save time by just calling Dr. Bloom since she stipulated to Dr. Chesser. I don't know if she stipulated to Dr. Bloom or not. We put it in just for judicial notice prior.
I
Do
don't.
you have any objection to Dr. Bloom's report?
Yes, I definitely would like to cross-examine Dr. Bloom.
Okay. Is Dr. Bloom available at 1:30?
1:30.
All right. So do you want to take a 15-minute break and then we'll get back together at 1:30 and we'll pick up with your next witness?
What I'd like to do is have an hour-long lunch during 15 minutes. And that isn't going to happen.
Well, what I'd like to do is after that witness, do you have any other witnesses or evidence?
I'm discussing with Ms. Lewis, just trying to save time because I want to get through this today. So I may not call Dr. Cheshire. She has a complete report.
That's fine. So you have one, possibly two other witnesses. Anything other than the two doctors?
If Mr. Bernstein does not show up, I'm going to read 3 snippets from his party deposition.
Okay. And then Ms. Garcia, how many witnesses?
improper without proper presentation.
How many witnesses do you intend on calling?
Depending what happens with Dr. Boone, 1 or 2.
Okay, so what I'll do is we'll take 15, we'll get your one witness on. If you decide whether or not you're gonna call Dr. Cheshire, then maybe we'll do both of them, and then we'll break. I'll give you guys an hour for lunch, and then I'll let Ms. Garcia make her motion and call her witnesses depending on my ruling on her motion, and then we should have all of the evidence in so that this portion can be submitted to the court. Sound good?
Yeah, except I will read the party deposition for less than 60 seconds.
We'll take that up at the appropriate time. All right, I'll be back in, I guess now it's 10 minutes.
Thank you.
What?
Yes.
Do you have a copy of the two reports that you moved into evidence?
Pardon?
Do you have a copy of the reports? The notice of filing, I guess you're.
Come to order, reports back in session.
Everybody can be seated. Looks like everybody's back. Mr. Sweetapple, let me turn it over to you to call your next witness.
Thank you, Your Honor. May it please the court. Before I do, I'm going to ask if Ms. Lewis can assist us here. I am led to believe that this mental health
I'll call
report.
you back. I just got a call from a court. I'll call you back. Bye.
That this report would need to be under seal, and also that no one other than the doctor can be observing this presentation. So I'll let Ms. Lewis address that. I'm not an expert in guardianship or mental health.
There was an incident in regard to matter where somebody refused obtained copies of the original committee report and did a story about it, Sahm, and showed copies of her confidential medical committee report on, I think it was CBS well. So we have a concern that if there are public observers on Zoom, because we have no idea who the report is, there are people who have attempted to health, that they would take that testimony and go back to that. Because this is information that is confidential.
Might be necessary.
Information that
Yeah, quick.
All right,
That is correct. I am making that request based.
Ms. Garcia?
I'm going to object to that. This is an open and public courtroom. They're the ones that are bringing this issue up. They want you to make a determination of someone's capacity at a certain date and time based on the testimony of a committee member. So I firmly believe this is open. They're the ones that brought it out into the open. They're the ones that have moved this into evidence.
I guess while the guardianship proceedings are certainly have a different level of privacy, this is it's a foreclosure action. So I guess what authority do I have to prohibit the public from having access to the court? Is there a statute or anything that says that? Because let's say, for example, this was a car crash and it was a loss of consortium claim, or there was testimony about a traumatic brain injury or something like that, where it would be the same issues. It would still be a public courtroom. I wouldn't be able to deny the public access.
Your Honor, may I speak?
Are you counsel of record?
No, I'm not. My name is Ms. Holt. I'm a member of the Guardianship Improvement Task Force, and if I could just say nothing about any of the...
I'd object, Your Honor.
Even in probate hearings, there's a statute, and it says a closed probate hearing is forbidden. The only person, it's Rule 5.540 hearings, and it specifically says an election to close the hearing may be made before the hearing by filing a written notice. And the only person that can close it is that person who's been adjudicated incapacitated. So even if this was a probate proceeding, hearings are open. So I'll put myself on mute and thank you, Your Honor.
Thank you, ma'am. I don't see any legal basis to close a circuit civil proceeding that is not a probate action, it's not a guardianship action.
And what about sealing the reports that are in evidence?
If the reports that are in evidence are reports from the proceedings, then I think there is a basis to seal that evidence because it's evidence that is that comes from a closed proceeding. So I would order that those be sealed pending further order of the court. But as far as the testimony, I'm not gonna dismiss the observers.
Understood.
Gotcha.
May I proceed?
Sure.
Thank you.
Who are you calling?
I'm calling Dr. Bloom.
Dr. Bloom? Dr. Bloom, would you raise your right hand for me? Dr. Bloom, can you hear me?
Can't hear.
Dr. Bloom, can you hear me?
He's deaf, Your
You're on
Honor.
mute?
88.
He's not on mute. He's not responding. Dr. Bloom? He can't hear. Is he connected to audio? It looks like he's connected to audio. Let's see if I mute him and ask him to unmute himself. Let's see if that works. Dr. Bloom, can you hear us? Perhaps if he disconnects and reconnects, it might. Can someone communicate with him to ask him to disconnect and reconnect? Mr. Bloom, can you hear us? Or Dr. Bloom, can you hear us?
You can write a note on the screen.
It comes up reversed.
Does it?
Learn that the hard way.
You've done that.
I can try to send him in the chat. Dr. Bloom, can you please try to reconnect? You may need to turn up speakers on his computer. Does anybody have Dr. Bloom's phone number to call him?
Because he's on the phone.
Send any questions for Inger to cross Bloom on.
See the green coming up.
That's why I think perhaps the speakers are just not.
Can we chat and turn up
I
our speakers?
have asked him to reconnect. He's not responding. He's not doing anything.
He's not getting the calls. Maybe he wants to do it.
Still going on if you want to log in. I will have video.
Can you hear me?
Yes.
I can't hear you.
Can you hear me from here?
And my unmute is, I'm unmuted.
Right, we can hear you.
Can you hear us now?
I think it's his computer speakers.
Pardon?
I think it's his computer speakers. He either needs to reconnect or.
Okay, looks like he's.
That wasn't me. I like it, but it wasn't.
Yeah. No, Candy isn't on here recording.
Honesty is the best part. I'm gonna use it. So, he's just turned his video off. Maybe can you tell him to give you a phone call?
And he's not licensed in Florida. A urologist. Right. All right, love. Yeah, tell that to Inger too.
Agent Dr. Bloom, can you hear us? Are you able to hear us, sir?
Hello? Hi, I'm not hearing. That's what
Earth Detector Bloom.
Yeah, that's not.
Earth Detector Bloom.
I didn't see that, but I'll try it again. Okay.
He indicated that he would try again. Okay. Right. Do you want me to step off the bench so that we can work out the AV kinks and then I'll come back once it's working?
I have no
You want me
problem.
to stare at you all while we're working our way through?
How about if we just see if this miraculously works before we do that? Dr. Bloom, can you hear me?
Does not appear that he can hear you.
No, it does not. So how about if we just ask the bailiff to summon you when we're
All right.
working? Thank you. Dr. Bloom, can you hear us? Or do we need to use?
I can try it on my phone.
Yeah.
Shall we talk on the phone or what?
Can you hear me from here, Doctor? Can you
Yeah,
hear
I
me?
can hear you.
Okay, let's see if we get to. So we can do it through the phone.
I do not have that. All I have is a microphone that says mute or unmute.
Okay, nothing on hearing us, no volume control? You checked your volume
There's
control?
no join audio, it just says mute, it just shows a microphone. And when I speak, the microphone reacts.
Whose phone are we listening to?
I can try it on my phone. and
Yeah, let's
if I
see
get
if-
better.
Yeah, this seems to work. Let's go ahead and, can we get the judge? I think this, here's he can hear counsel.
Give me a
Yeah.
minute and I'll try it on my phone.
No, just stay, do what you're doing because this is working.
I'm trying,
Well, what's wrong with you holding? Dr. Bloom, can you hear us? Dr. Bloom, can you hear us?
His hearing aids off.
We were just,
yes,
can you hear me?
I hear you.
Fine, okay. Your Honor, may we proceed?
Sure. Dr. Bloom, can you raise your right hand for me? He can't hear me. I think it's because you're talking on the phone. So what Dr. Bloom's going to need to do is he's going to need to put his video on mute, or I can mute him.
I hear you now,
Can you hear me now?
yeah,
Can you raise your right hand for me?
yes,
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, you can put your hand in now. And Mr. Sweetapple, you may inquire.
Thank you, Your Honor. May it please the court. Dr. Bloom, would you please state your full name for the record?
Stanley Bloom,
And are you a licensed medical doctor?
say again, please?
Are you a licensed medical doctor?
Yes, I am.
And how long have you been licensed?
About 50 years,
And where are you licensed?
in New York and New Jersey.
And have you ever been appointed by a Florida court to conduct an examination of an alleged incompetent or incapacitated?
Yes, I have.
On how many occasions have you been so appointed?
Say again, please?
For how many years have you been appointed by Florida courts to,
Since 2013.
a dozen years?
Yeah,
And how many examinations of alleged incapacitated persons have you conducted for the Florida courts?
I average about 150 to 200 a year, about 1,000.
And do you have your records in front of you regarding an examination you conducted on May
Yes,
5th,
I do.
23 of Patricia Sahm? You have that?
Yes, I do.
All right, and can you tell the court what you did on that date?
Say again, please?
Can you tell the court what you did on that date?
I interviewed the alleged incapacitated person.
All right, and how long did you spend with her?
Oh, it's over a year ago, I couldn't tell you.
All right, and that was on Zoom, was it not?
Yeah.
All right, and do you remember your mental diagnosis of her, or would you need to review your records?
No, I remember it. I thought she had dementia,
Oh.
probably Alzheimer's type.
All right.
That's in the foundation.
What part of the foundation is lacking?
Pardon?
There was an objection, and I asked for clarification on the objection.
Specifically this case, as far as appointment, was he even appointed?
Overruled.
Were you appointed by Judge Burton to conduct an examination of Patricia Sahm?
I did, Are you talking to me?
Yes, sir. Were you appointed by Judge Burton to conduct this examination of Mrs. Sahm?
Yes, it was.
All right. And under mental diagnosis, what did you conclude?
I concluded that she had dementia, she had a loss of long and short-term memory, she was cognitively impaired, and she was not oriented in time, place, or person.
Was she clear regarding her finances?
No,
Did she know specifics regarding her assets?
no,
Did she know how much money she had?
no.
Was she aware of the guardianship?
She didn't understand the concept.
Did she remember receiving copies of the petition?
I didn't ask her that specifically.
Okay. And did she remember seeing her attorney?
I didn't, she did not.
All right. Did she know what medication she was taking?
No, she did not.
Did she know who the governor or vice president is?
No.
Could she multiply 9 times 7?
Could she what?
Multiply 9 times 7.
No,
Did she know how many quarters are in $6?
no,
Could she subtract 7 from 100 serially?
no,
Was she aware of the pending litigation regarding this property?
no.
And what is a MOCA score?
Say again, please.
What is an MOCA score?
I'm having trouble hearing you.
I see in your report that her MOCA score is 18 out of 30. What is that?
Yeah, she had a MOCA score of 18.
Can you explain to the court what that is? What is a MOCA score?
That's a screening test for Alzheimer's disease. I did not perform the test, but I saw the report from another examining member community.
Right. And
member who performed it.
I see in your report that Stephanie Cheshire and Brendan Cheshire were
Yeah,
present.
she did that examination.
So you did review a MOCA score regarding her Alzheimer's?
Yeah, with Stephanie.
Right. And what does the score of 18 out of 30 indicate?
It indicates there's
Outdated.
cognitive impairment. It's a screening test, but it indicates above 17 indicates moderately severe cognitive disability.
And she had these conditions
There's
on
an
May
object-
5?
Hang on, there's an objection.
Did she what?
There's an objection at foundation, the objection is overruled. Next question.
Thank you. Did she have these conditions when you saw her on May 5, 2023?
Yes,
And did you consult with Dr. Cheshire and Mrs. Cheshire regarding?
yes, I did.
And I see that you did a functional assessment. Did you find that this Sahm is able to travel alone on public transportation?
Objection, leading.
I did not think so.
Overruled.
No,
Did you find that she was able to drive her own car?
no,
Did you find she was able to shop alone for food and clothing?
no,
Okay. And those were your findings, no?
no.
What did you find with regard to her ability to take her own medication?
I thought she did not have the ability to manage her medication.
What did you find with regard to her ability to manage her own or handle her own money?
I thought she did not have that ability as well.
Right, so you were asked in section 6 to indicate if you thought Ms. Sahm lacked the ability to exercise the following rights. Did you, in fact, find that she lacked the ability to knowingly marry?
Yes,
And what about the contract? Did she lack the ability to contract?
yes,
Did she lack the ability or to exercise the right to have a driver's license
yes,
and to travel?
yes,
Did she lack the right to seek employment?
yes,
and to determine her own residence.
Yes,
Did she lack the ability to consent to medical treatment?
yes,
Did she lack the ability to apply for government benefits?
yes,
Did she lack the ability to sue or be sued?
yes,
And what about manage or dispose of her property?
yes, like the ability.
All right. And did you sign a report for the court on May 5th, 2023?
Yes,
All right. And I can show them a copy on the screen if needed, Judge, to see, have them authenticated. Is that necessary?
You seeking to enter it into evidence?
Yes.
How would it not be hearsay?
Pardon?
How would it not be hearsay?
All right, so I won't move it in. So you did issue a report, correct?
correct.
And provided it to Judge Burton?
Overruled.
Say again?
You did issue a report and provided it to Judge Burton?
Yes,
Were you asked to testify at any proceeding?
yes,
And did you give testimony consistent with that testimony you've given today?
I didn't what?
Did you give testimony in the proceeding before Judge Burton consistent with the proceeding, with the testimony you gave today?
You're breaking up, I'm sorry.
I apologize. Did you give testimony in the proceeding before Judge Burton that was consistent with that testimony you gave here today?
Yes,
And these conditions that you have described here, could they have just occurred the day before the meeting or the week before your examination?
no,
Overruled.
unlikely.
All right. How long do you believe these conditions were present?
Well, Alzheimer's disease is a slowly progressive, irreversible disease that occurs over time and is not an acute disease.
And so over how long of a period do you believe she's progressed to this stage?
It's hard to say. It could be, it's been presumably some time, but I can't say when it began.
With respect to the speculation objections, the doctor has testified he's a licensed doctor for approximately 50 years in 2 states. He's been testified that he has, for the past 12 years, been appointed to inspect incapacitated persons. He's inspected approximately 1,000 individuals in total. I find that he has established that he's qualified to render an opinion. So I'm overruling the speculation objection.
Based on a MOCA score of 18 out of 30, has this been an acute case of Alzheimer and dementia?
That test does not distinguish acute versus anything. It's just a screening test for cognitive ability.
All right, and you don't rely on that exclusively, do you? You do not rely on the MOCA test exclusively. You interviewed the patient, correct?
I'm sorry, you're breaking up again. I'm
I
sorry.
take it you do not rely on the MOCA screening test alone. You do a detailed interview of the patient,
I
correct?
don't rely exclusively on this screening test to render my opinion.
If I could have one moment, Your Honor.
You may ask.
Thank you, Doctor. I have no further questions at this time.
All right, cross-examination. Ms. Garcia, it might help if you're by that microphone. I think his audio is coming from that phone.
On the phone.
Yeah.
Good afternoon, Dr. Bloom.
Good afternoon.
Nice to meet you, sir. When asked a question on direct about your report and your findings, you testified that you found that Ms. Sahm had dementia, correct?
Can you lower the microphone? Maybe I can hear you better. Not that low.
I'm short.
Okay.
On direct, you testified that your report made a finding that Ms. Sahm had dementia, correct?
I'm really sorry, you're breaking up. On the report, what?
You testified that Ms. Sahm had dementia?
When Laura asked the question about your findings, isn't it true that you testified that your report stated that Ms. Sahm had dementia?
Did my report state it in the report? I'd have to read the report to see if it was stated there. I
Do you have
can't
the-
tell you what off the top of my head.
Do you have the report in front of you, sir?
Yes, I do.
Could you please refer to your report, page 1?
Which report do you want? The 23rd, the first one or the second one?
The first one, Your Honor. I'm sorry, the first one. Dr.
I
Blair.
don't have a third one. I have a first and second one.
She said the first one.
The report dated that that the attorney had read the statements off the report to you, and you were confirming what he was saying. Your report dated May 5th, 2023.
Yeah, that's good. I can hear you now. Yeah,
Okay.
what about it?
Isn't it true that on direct you testified that your report stated that Sahm had dementia?
No, here, I testified I believe she had dementia. I didn't testify the report had dementia.
Isn't it true that in your report you only stated she had long-term or short-term memory?
She has loss of long and short-term memory, correct?
How first of all, how did you appear at this
How do I,
evaluation? Were you there in person or on Zoom?
I'm sorry.
How are you there to analyze or to evaluate Ms. Sahm?
I interview her.
Did you do it in person or on Zoom?
I believe I did it on Zoom. My memory is a little vague on it. It's a long time ago, but I believe I did it on Zoom.
And when you did this review of Sahm, was Stephanie Cheshire and Brennan Cheshire present at that?
You know, I did 2 exams on her, and they're over a year ago, and I know I did one remotely, and I know I recall, at least in one of them, that Stephanie Cheshire was there, but I can't tell you which one or
Having a problem with
No.
their long-term memory, huh?
when they were there. It's too long ago.
Isn't it true that these reports and these evaluations are supposed to be done independently of the other committee members by law?
When we were trained, we were encouraged to review our reports with other members of the examining committee.
But you can't rely on their findings.
I do not rely on their findings.
But you relied on the MOCA test, the score of 18 out of 30, correct?
I rely on my interview, any medical information that I receive, any discussions I have with members of the examining committee, the medical past history, the psychiatric report, which I have access to, and any other information that is made available to me. I do not rely on any one specific thing.
Didn't you testify on a direct examination that a MOCA score of 18
Can you
was
talk directly into the microphone? You get real close, I can't hear you.
in your direct testimony? Am I correct when in your direct testimony, you testified that a MOCA score of 18 is an acute cognitive deficiency, correct?
Incorrect, I did not say acute.
So when the attorney told you it was acute, you said, yes, that's not true? That an 18 is actually a mild cognitive impairment function?
It indicates that there's significant cognitive impairment. That's what I stated, and that's what I mean.
So who conducted the MOCA test in this? Out of the three of you.
Stephanie Cheshire.
She doesn't have the ability to conduct MOCA tests legally? She doesn't have the training or certificate?
That's not true because I've done other cases with her, and in fact, she is trained to do it.
Oh,
You said Stephanie is the one who conducted it? This is Stephanie Cheshire? Correct?
You have to get close to the microphone again, please.
Did you state that Stephanie Cheshire is the person that conducted the MOCA test?
Stephanie Cheshire is the person that performed the test.
It was Stephanie Cheshire, the social worker?
I believe she is, but I'm not intimately familiar with her credentials. I'm sure they're available to you if you wish to see them.
Are you aware that Stephanie Cheshire allowed her social worker status to expire and she's still conducting MOCA tests illegally?
I don't know if that's factual or not. I can't tell you.
speculation. And he doesn't know. Next question.
How long were you on the Zoom when you conducted this evaluation?
How long was on? Say again?
How long were you on Zoom when you conducted this evaluation of Miss Sahm?
How long did it, the time I conducted the evaluation? I can't tell you, it's over a year ago.
When you testified on direct that you didn't ask Miss Sahm if she remembered receiving copies of the petition, is that true or is your report true?
I didn't hear the question completely, but I have a copy of the petition, if that's what you're asking.
But you testified that you did not ask Miss Sahm if she remembered receiving copies of the petition.
If I didn't ask who?
This is Sahm,
Oh, I hear what you're saying. Yeah, she apparently did not remember, right?
Why is your testimony inconsistent with your report?
I don't think it's inconsistent. If you point out the inconsistency to me, I'll try to clarify it for you.
On direct, you testified that you did not ask her about receiving a petition. However, in your report, you state that she doesn't remember receiving the petition. Which statement is true?
I stated what?
Let's go, I'm going to move on. Let's go to page 2 of your report, sir.
Which report are we looking at, 23 or 24?
23.
May? The May report?
Yes.
Okay, what do you want to know?
Page, can you please look at page 2, look at 4.0?
Page 2, yeah, 4.0?
Yes.
Right.
Isn't it true that your recommended course of treatment was that the AIP is in good physical health and she can continue to live independently?
Right, that's what I wrote.
Where in this report does it say she has Alzheimer's or severe mental cognitive issues?
I'd have to look at the report, whether it says it or not, but that's indeed what she has.
Is that based on your May or your second report that wasn't used in court?
Say again, please?
I'll move on. Can we please look at 5.0, functional assessment on your report? It's on page 2.
You're saying, you're talking about item 3, is that what you're asking me about?
Item 5.0, functional assessment.
Yeah, okay, go ahead.
Are you aware of Florida statute 744.102 that discusses what determines whether an AIP is incapacitated or not?
I couldn't cite it, I couldn't review or state what that says specifically. If you want to read it to me, I will tell you whether I'm aware of it or not.
Okay, were you aware,
Ask him if he ever applied for
were you aware that to find someone incapacitated, you need to consider their health care of themselves, their ability to feed themselves, their appearance, and their ability to clothe themselves.
I've did over 1,000 evaluations. I'm quite aware of the requirements that you need to determine whether a person is incapacitated, and based on the evaluation I did, I rendered an opinion that indeed she is incapacitated.
So let's look at section 5.0. Isn't it true that you found that she can shop alone for clothing and food? You have a Y next to it.
That's a typo. There's no. It's why no. The Y is a typo.
Isn't it true, in the next line, you said that she, Mrs. Sahm, can prepare her own meals, correct?
I have to look at the report because I certainly don't remember.
Look at page 2, 5.0, functional assessment.
Yes. Yeah. Yes, she can prepare her own meals.
And if you go to the next page,
Yes.
it's the fifth one down. Isn't it true you found that Miss Sahm could take care of her own personal appearance?
Yes.
And isn't it true you found Miss Sahm could socialize with her friends?
Yes.
Isn't it also true that Florida has denied you receiving your license to be a doctor here since 1984?
The court has denied me.
The
What?
Florida Department of Health, where doctors are licensed in this state, you have been rejected to be a doctor in the state since 1984. Isn't that true?
No.
You applied to be a doctor in Florida and you were denied, correct?
Did I what?
You applied to be a licensed physician, what, gynecologist, I think?
I'm
In
not a
Florida?
gynecologist. I'm not a gynecologist. I'm a urologist. And I did not
Okay.
apply for a license in the state of Florida.
Ever?
Ever.
Are you aware that I did a 119 request for your application here and with the Department of Florida? There's
I'm aware.
proof that you were denied being a doctor in the state?
Am I aware of the allegation? No, I'm not aware of the allegation.
Are you aware that when Are you aware that there's a relationship, a legal relationship between the other two committee members, Dr. Stephanie Cheshire and Brennan Cheshire, and that's against the laws for committee members?
The sustain that.
I have no knowledge of what the rules are, nor is it relevant to what I do.
I'll allow his answer to stand.
You testified on direct that you gave testimony in front of Judge Burton in relation to
Yeah,
this.
I believe I did. I believe I did, yeah, but my memory is vague on it.
Isn't it true that you actually did not testify in Judge Burton?
It's quite possible. It's quite possible. All of this happened over a year ago, and I'm not sure of times and dates and who I testified in front of and who I didn't testify in front of. So it's possible I'm incorrect. I don't know.
So your last statement wasn't true then?
Same answer.
Isn't it true that a MOCA score of 18 out of 30 only signifies a mild cognitive impairment?
Mild to moderate, and it's only one part of the diagnosis. There are multiple factors that you consider when making the diagnosis, one of which is the MOCA test.
Isn't it true that to have a moderate cognitive impairment, the score must be between 10 and 17, not 18 or above?
I beg your pardon?
Isn't it true that according to the MOCA test, that to have a moderate cognitive impairment, the score must be between 10 and 17?
There's a cutoff point, there's 17 and 18, it's moot.
Where is that in the MOCA testing?
I'm giving you my
Protocols.
opinion. My report is based on my opinion.
And your opinion was based partially on this MOCA test, correct?
My opinion is based on my evaluation, the report of the neurologist, my conference with my other members of the examining committee, the medical information that's available to me, the interviews that I carry out if I carry out any with a family member. It is not based on a MOCA test.
There's nothing in your report that refers to you reviewing any medical records, sir.
There's nothing in my report, what?
There's nothing in the report that refers to you reviewing medical records. Is your testimony here today now that you reviewed medical records to make a decision? You're saying outside medical records?
When medical records are available, I review them. The medical record that I have is a record from the Neurological Disorders Clinic by a neurologist who found that Patricia Sahm has Alzheimer's disease, is unable to make any decisions about where she will reside, lacks proper character judgment, cannot decipher genuine relationships from scams or tricks. She is not able to determine who is safe to socialize with. As a result, she is unable to handle her own financial affairs or any legal contracting. If you have any questions, you can call the office. That is the report from Fernando Nerono, neurologist,
Date, please.
June 26, 2024.
Okay, June 26, 2024, you're relying on a report that's a year and 2 months after this to make your findings, sir?
As I said before, I don't rely on any one thing. I rely on all the information available to me plus my own evaluation.
Which was involved for a time you don't remember. A month of time you don't even remember.
Say again?
I'll withdraw that question, Your Honor. Did you read Dr. Schiller's report?
Did I read whose report?
Dr. Schiller, who gave an opinion for the AIP's attorney?
I
Did
don't
you
have
read his
that.
report?
I don't have that in front of me right now.
But have you read it?
I don't recall reading it.
Are you sure?
I don't recall reading it.
Well, you keep talking about a second report you did. Isn't it true that the 3 committee members were removed in 2024?
Isn't it true what?
He's testified to it.
Although it would be helpful in my case, it's still not a law. Overruled.
You referred to the fact that you did a second report in 2024, correct?
I'm sorry, I didn't hear you.
You referred to the fact that you did a second report in 2024, correct?
I evaluated her twice, correct.
And isn't it true that that was not used by the court, and the court appointed 3 new committee members?
Isn't it true what?
That those reports were not used in 2024, and the court appointed 3 new committee members.
You're breaking up something about 2024 and 2023.
Is it true that after you wrote the report in 2024, that they were not used because the court appointed 3 new independent committee members?
I'm not aware of that. That's possible.
Somebody get a guardian for him.
In a moment, Your Honor. One second, Your Honor. No other question. I have no other questions of this witness, Your Honor.
Any redirect examination, Mr. Sweetapple?
This witness, however, I am going to ask for leave to call Ms. Lewis for 2 minutes as to why parties stipulated to,
May I dismiss Dr. Bloom?
yes, I'm finished with Dr.
All right,
Bloom.
thank you very much, Dr. Bloom. You can log off the Zoom.
Thank you, Dr. Bloom.
Thank you. Am I dismissed?
Yes,
Thank you very much.
thank you.
I'd like to, if I could, Your Honor, briefly call Attorney Lewis just with regard to what happened with regard to the 2024 panel, since there's an attempt to create some impression that he was disqualified some.
All right. Is she on the witness list?
No, but this is by way of rebuttal.
All right. Why don't we?
I object, Your Honor, there's prejudice, and he could have reasonably understood that when he was calling this witness, that there would be issues as to the admissibility or lack of admissibility, testimony or use of these reports.
But his reports are not in that.
And 2024 was not relevant time period.
And the decision that I have to make is not whether or not she qualifies as an incapacitated person. We're getting way far afield, but you know what? I'll let you call Ms. Lewis, I'll let you cross-examine her, and I'll take the evidence for what it's worth, which may not be germane to the court's conclusion, but come on up, Ms. Lewis.
I don't think it is relevant to the court's conclusion. However, I think there's been a misimpression created.
Would you raise your right hand?
Evidence you're about to give will be the truth, the whole truth, and nothing but the truth. I do.
All right, put your pep on your way up. Mr. Sweetapple, whenever you and Ms. Lewis are ready, you may inquire.
Thank you, Your Honor. Could you please state your name
Yes, my name is KATHRYN Lewis.
and how are you employed?
I'm a partner at KITROSER, Lewis & Duke.
And are you a licensed Florida attorney?
Yes, I am.
How long have you been so licensed?
Since 2000.
And are you counsel for Charles Rivard, the guardian of Ms. Sahm?
I am.
And were you involved with regard to evaluations of Ms. Sahm again in 2024 after the 2023 that are the subject of this controversy?
In 2024, myself and Mr. KITROSER were representing Mr. Rivard at the time that those evaluations were performed. We did not personally have any involvement in the actual evaluations.
And did counsel for anyone request that there be a reevaluation in 2024?
Yes, we filed a petition to determine incapacity and a petition to expand the guardian's powers in order to give the guardian control or ability to make decisions regarding Mrs. Sahm's residence and social environment, which were 2 rights that were not removed in 2023.
And did the court grant that expansion?
Yes.
Right, and was there a new examination committee appointed?
Originally, after we filed the petition to determine incapacity in 2024, the court reappointed the committee from 2023 to evaluate Mrs. Sahm again.
And what happened?
They did their evaluations, they filed their reports. Thereafter, attorney Laura Burkhalter, who had been court appointed to represent Mrs. Sahm in the 2024 incapacity proceedings, filed a written objection to those committee reports. And as part of the grounds for her objections, she stated that because this was the original committee from 2023 that had previously found Mrs. Sahm incapacitated, that it was an infringement on Mrs. Sahm's presumption of capacity.
And was a new committee appointed?
Yes, we actually agreed, Mr. KITROSER and I, on behalf of Mr. Rivard, we agreed to the appointment of a new committee to remove that from being.
And that committee, did it also determine that she was
I
incapacitated?
think it's relevance.
And did they recommend an expansion of,
Sustain.
no further questions, Your Honor?
Any cross-examination with respect to?
Cross the bridge.
Were you the attorney in May of 2023 in the guardianship and mental health case?
I personally was not involved in the case in May of 2023. I'm not sure whether or not Mr. KITROSER had been retained by Mr. Rivard at that point. Personally, I'm not sure.
Isn't it true that your law firm and Mr. Rivard were even brought into this case until June of 2023 by agreement
I don't.
of Miss Amber, Miss Patwell?
I don't know what standing Ms. Patwell would have to agree as to whether or not Mr. Rivard retained my law firm.
So you don't know if there was actually testimony given to Judge Burton, do you? In May of 2023 or June of 2023?
Personally, I don't know. I believe there was agreement among the parties. Ms. Patwell withdrew her objection to the committee reports. You, on behalf of the Bernsteins, did not pursue an objection, from what I understand. And because there was an agreement, the court entered an order adjudicating Ms. Sahm incapacitated.
Isn't it true that the order doesn't actually have a date of adjudication or determination of the incapacity? It's blank.
How is it? Wouldn't the order be the best evidence?
I'm sorry?
Wouldn't the order be the best evidence?
Well, since there's a lot of issues here going to the mental impressions of the capacity, non-capacity, and the ability to enter into contracts at that time, I think it's very relevant that there was no due process finding of incapacity by the court. I guess that question.
I guess I don't see how, with all due respect to Ms. Lewis's knowledge of the date, whether or not the order contained a date is relevant to the issues that we're here to decide. So I'm sustaining the objection as to the best evidence. If you want to provide the order and show me whether or not it has a date, I can read it.
I'll do that because it's an evidence. Okay, thank you.
All right. Thank you. Any redirect examination? All right. Yes, ma'am. You may step down. Any additional witnesses or evidence on behalf of the claim?
Just the, on the party deposition.
All right.
Good. Agree. And I don't think we have copies. Transcript, I think.
No. Hold on, Your Honor. I object fully. You cannot just use a depo. This is improper impeachment. You want to use a deposition for a witness, you can use it if you find that the witness is dead, which he's not. He's greater than 100 miles, which he's not. He's out of state, which he's not. And it doesn't appear that he's absent. He never gave proper notice prior to the trial of using a deposition. You can't use a deposition to impeach a witness when he's not here and he's available. He could have been subpoenaed. So I believe it violates Rule 1.330. And basically,
I'll tell you one.
he cannot use the deposition under 1.1330A. And he hasn't given a proper notice. It's a due process hurdle he has to overcome. And I can cite all the case law if you'd like, Judge.
Sure. It's like any case that says you can't use deposition of a party opponent.
As the way he wants to use it when the party's available and he didn't subpoena him. He can't come in here now just read a deposition without proper notice. Proper.
Cite the case that said.
They said that basically, let me see. Okay, the 4th District has a case that says that the rule,
What's the name of it?
let me see.
What's the citation?
I'm gonna give you, hold on one second. First of all, there's a hearsay hurdle to overcome under Rule 1.330. And basically, they said that under Dinter versus Brewer, 420 Southern 2nd, 932, Florida 3rd DCA 1982, the court found that hearsay was inadmissible because it didn't satisfy the provisions of the former testimony rule. In other words, the rule itself is only exception to the hearsay rule.
Isn't prior sworn testimony of a party opponent taken at a deposition subject to cross-examination specifically an exception to the hearsay rule?
Cross-examination, right, but
Subject to cross-examination, not
I
cross-examination.
believe the rules, Your Honor, allow the opposing party's deposition to be used at any time for any purpose. It's been my use of them for over 40 years, and I've never had anybody say I couldn't do that, so I'm ready to be corrected if I'm wrong.
I believe it's a due process violation to allow him to use a rule against a party who has not testified, who he's not subpoenaed, he's not called as a witness, and he's coming in here using a deposition without proper notice. The rule does say you have to give me notice and a copy of the deposition. My client never, and it's also he has to be unavailable if he wants to use a deposition, or he would use it on proper cross-examination. You can't use a deposition as direct testimony. Not the way he wants to use it. It's not following the proper rules.
Mr. Bernstein was here at our last setting, and I have deposed him and intended to cross-examine him. He's not here today, and I believe I'm entitled to use his testimony from the deposition as a party opponent for any purpose at any time. She could call him if she chooses to. He's a party.
Rule 1.330 A. Use of depositions. On any hearing of a motion, any part or all of deposition may be used against any party who was present or represented at the taking of the deposition, or who had reasonable notice of it, so far as admissible under the rules of evidence applied through the witnesses who were then present and testifying in accordance with any of the following provisions. Subsection 2, deposition of a party or of anyone who is a person or agent designated may be used by an adverse party for any purpose. So I'm overruling your objection.
And also, Your Honor, in A1 does discuss the fact that if you want to use it for the purpose of contradicting or impeaching any testimony of the opponent as a witness, you do have to follow the evidence code. You do have to give proper notice. You can't just come into the court with a deposition that hasn't even been read.
When was this deposition taken?
This deposition was taken October 2nd, 2020.
All right. And was it listed as a potential exhibit or item of evidence?
No, Your Honor.
We took this after all that occurred. It took us forever to get Mr. Bernstein into the deposition, if you recall.
All right. When did you determine that you were going to use your deposition?
I was going to use it for cross-examination today. However, I noted that for some reason, Mr. Bernstein, who sat next to her the entire proceeding in August, is not here. So
Is Mr. Bernstein present on Zoom? If so, can you unmute yourself? Deputy, could you sound the hall for Mr. Bernstein? Right, Deputy's indicated that Mr. Bernstein is not present, so I find that he's not availed himself to be cross-examined here in court, so it would not be fair to the other party to not allow that portion of his testimony to not be provided to the court. I'm overruling your objection.
Your Honor, if I may, I'm reading from page 76, starting at line 4. Question: and how many times did you meet with her before the guardianship was filed? Answer: probably most of the times. Question, well, after the guardianship was filed, did you still meet with her and try to get her to sign a settlement? Answer, I have to look at my notes and figure that out, but. Question, didn't you appear at her house on more than one occasion before she signed the settlement agreement to meet with her? Answer, I did. Question, okay, and you had the settlement agreement in your hand when you met with her, right? Answer, I did. Question, this is at page 77, line 3. Didn't you, so you met with Mrs. Sahm after the guardianship had been filed, right at her house? Answer, yes. Question, on more than one occasion, correct? Answer, yeah, most likely. Then on page 88 at line 2. Okay, so you were helping Patricia Sahm Sr. find an attorney? Answer, yeah. Question, okay, and you asked everybody in the guardianship abuse group who you could get to represent Patricia Sahm Sr.? Answer, correct. At line 89, page 89, line 13. And so how did you learn that Miss Patwell had been hired after you recommended that someone go find an attorney for Mrs. Sahm? Answer, how did I learn? I think through Patty Jr. or something. That's all I'm reading you.
All right. Is there any portion of the deposition that you would like for me to consider according to the rule of completeness, Ms. Garcia?
Your Honor, I would need time. I will do that before the close of my case.
Okay. All right. Is there any additional witnesses or evidence?
Your Honor, I have no further evidence with regard to our motion.
All right. And then motion on behalf of, let me turn to Ms. Garcia first for your motion, understanding that you had entered evidence, but we just did that for expediency's sake. This is now the close of the plaintiff's presentation.
Plaintiff is arrested.
Yes, ma'am.
Okay, Your Honor, I'm moving for a directed verdict pursuant to Rule 1.480. The plaintiff has closed his case, and the plaintiff has not proved the necessary elements of the case. Firstly, excuse me, Your Honor, the plaintiff has not proved by clear and convincing evidence that Ms. Sahm was incapacitated in May of 2023. The witness had testified, was not forthcoming as far as remembering what happened, misrepresenting to the court the cognitive based on the MOCA test, misrepresented that he testified in front of Judge Burton, which didn't happen. There's testimony by Ms. Lewis. She wasn't involved in a case at the time, so nobody could confirm that there was any ever actually hearing or determination by Judge Burton that the client was incompetent. Also, Ms. Sahm did not have her due process or her right, the contract taken away by the court at the time the settlement was entered into. The evidence that is in evidence, his evidence, is that the settlement was entered into on May 22nd, and there was no finding of incompetency by the court, by any court order, or by any due process hearing until June, by agreement with the parties for limited guardianship for Charlie Brevard, who's her cousin. At the time, there's no proof that at the time that the settlement was issued, that there was any nefarious conduct by either myself or Ms. Patwell or the other attorneys, Morgan Weinstein. Simply put, that the plaintiff has not carried their burden for this court to determine, first of all, if there was any competency or not at the time. Further, they haven't proved, pursuant to the law, that, or rebutted by clear convincing evidence, like Harmon versus William, 596, Southern 2nd, 1139, of Florida's second DCA case. It says the court holds
that a person is presumed competent to contract unless incompetency is established by due process of the law. So this court basically would have to make a proactive finding that prior to any adjudication, that you're going to take away, retrospectively, a client's right to contract with a lawyer. It's clear that she had a lawyer, Amber Patwell, who was assigned and accepted by the court, and that there was a settlement that was entered into. They waited 14 months to try to set it aside. Then they tried to come in with allegations of the exception to the rule. So the court determines by clear and convincing evidence, he believes that the client, they did not prove incompetency sufficient for you to prospectively negate a legitimate contract that the guardianship court did negate, and nobody had even fought for a year. Then you'd have to get to the next level of the argument, which would be that there had to be some undue influence or some fraud. None of that has been proven as far as this settlement that was entered into, that was validly entered into with her having an attorney present. And the evidence that is in the other committee report that is in evidence, Your Honor, does say that she can contract with the help of an attorney, which she did. So there's nothing that has been proven here in his case in chief that would give Your Honor the ability to take away her presumed competency to contract. And there's nothing in the evidence so far that proves any fraudulent activities or undue influence related to the execution and timing of the contract. In fact, the evidence that was presented through the court orders and the dates and times show that as soon as Weinstein was hired, April 12th, and then there was no stipulation done and no settlements were negotiated. Mr. Weinstein had nothing to do with it at that point. The evidence shows that in May, there was a hearing in the bankruptcy court wherein the attorney, the retainers in evidence, represented the estate that has no rights. At one point, a dead man who they never told the court was dead. And then Ms. Sahm, that according to Mr. Sweetapple's testimony at the last hearing, or his proffers, were that she was incompetent, he was traveling under a power of attorney, but in the meanwhile, they're still moving forward, hiring lawyers and filing defenses that are not legally proper. Filing a claim in a federal bankruptcy court for a state that you've admitted has no rights is a fraudulent court. Filing claims for dead people for years, including the affidavits or evidence for dead people, is improper. So I don't believe that he's met his burden, according to the law, for either the declaration of an incompetency and or fraud or undue influence to set aside the agreement. So those are some of the specific reasons, Your Honor. You have in evidence basically that we would ask the settlement to stand as is, because the plaintiff has clearly not proven his case.
Mr. Sweetapple.
May it please the court. The evidence in this case is clear that the Bernsteins knew at all times that Ms. Sahm had declined into incapacity, and of that there can be no doubt. Ms. Garcia knew the same thing, because as you noted, she tried not to put in the signed settlement agreement that she forwarded to Mr. Raymond and in March of 2024. And that agreement prepared by her and signed by all of her clients, repeatedly recites that Mrs. Sahm Sr. is incapacitated. And I'll read to you some of those quotes. I have my highlighted copy, it'd be quicker than me looking at the unhighlighted copy, but
Page 2 of plaintiff's 12, whereas Walter Sahm Jr. is now deceased and his estate is pending in Marion County, and his now incapacitated wife, Patricia Sahm, has a power of attorney, trust, pre-need guardian with her daughter, JOANNA Sahm, whereas the estate trusts and the incapacitated surviving spouse.
Exactly.
Page 3.
this is an admission of their knowledge of her incapacity, that they signed this in March. It's a admission of Ms. Garcia's knowledge of her incapacity. And yet, what do we see? We see Patty Sahm Jr., the same person Judge Burton found was taking advantage of her mother and allowing a signature or a notarization of a revocation of a power of attorney to occur using the Bernstein's agent. Mr. Bernstein admits he's helping through Patty Jr. to get an attorney for his opponent, Mrs. Sahm. There's always the suggestion throughout this case, including my cross-examination of Ms. Inger, that somehow I was substituted in this case. But Patty worked with Mr. Weinstein. You can see through the communications. Had Mr. Weinstein come in, a friend of Mr. Hall's, to try to take over so they can backdoor a settlement taking advantage of Mrs. Sahm Sr.
That's not evidence.
So Mr. Weinstein lasts a few days. He never sends me a stipulation of substitution of counsel. I've represented Mr. and Mrs. Sahm since the beginning in this case. I represented Mrs. Sahm individually, and then when her daughter told me she had a power of attorney and Mrs. Sahm told me she had a power of attorney, I additionally was authorized to deal with JOANNA Sahm. But the bottom line is, they knew that I was the attorney in this case, and all of this is occurring without any attempt to have me join in on either of these settlements. And you're going to see if, and this is not appropriate this time, but you're going to see I was not copied at my email address with communications that had been represented that I didn't respond to. So what happens? Well, this fraud that's occurring involving Patty, Inger Garcia, and the Bernsteins, and Miss Atwell, who's brought in by the Bernsteins, is just a continuation of a fraud that the bankruptcy court already occurred by Miss Garcia in the state court. And 3 days before the guardianship's filed, the federal court grants interim relief from an automatic stay that Ms. Garcia obtained. And if you look at paragraph D, attached to the motion as Exhibit D is a copy of the suggestion of bankruptcy for defendant and notice to cancel sale set for April 4, 2023, parenthetically the suggestion of bankruptcy, filed on April 3 by attorney Inger Garcia on behalf of certain defendants, including debtor Eliot Ivan Bernstein in the state court case. The suggestion of bankruptcy is factually false and legally incorrect and was designed to mislead the state court and or the clerk of the state court into canceling the April 4, 2023 foreclosure sale of the real property scheduled in the state court, because the suggestion of bankruptcy stated that, quote, this action is founded on a claim for which a discharge would be released and that seeks to impose a charge on the
Which
property.
shows the fraud in the state court.
This is the second fraudulent bankruptcy. The first one, the sons are all assessed $43,000. This is the second fraudulent bankruptcy. But Ms. Garcia is representing the Bernsteins. They're fully aware of the guardianship, as is she, because watching all of this occurring, the first thing I do when I hear for the first time that there's been some alleged revocation of a power of attorney, which would not have in any way affected my direct representation of Mrs. Sahm, who was my client and always competent the entire time I knew her. But I'm dealing now with JOANNA for the last couple of years at Mrs. Sahm's direction. So when I call Mrs. Sahm, and I put this in a notice so that all counsel would be alerted that we're watching you, don't continue with your fraudulent conduct. What do I do in my request for judicial notice? 1, plaintiff is a surviving spouse and owner of the note, which was the subject of the instant matter. 2, undersigned counsel has been advised that a revocation of the current power of attorney held by Mrs. Sahm's daughter, JOANNA Sahm, has recently been executed. 3, undersigned counsel spoke directly with plaintiff Patricia Sahm yesterday. Mrs. Sahm indicated she was unaware of any such revocation and still wanted undersigned counsel to represent her in this matter. 4, the court is further advised on requested to take judicial notice of the pending guardianship matter, and I cite them. So while on May 5th, all 3 committee members find that she's unable to manage her litigation, and Miss Hadwell is not counsel of record. There are attempts by documents prepared by Mrs. Garcia, Mr. Bernstein's going to the alleged incapacitated person's house, and on the 22nd of May, obtains her signature when no one else is there.
Objection, facts not in evidence.
So, I don't mean to cut you off, but this is a motion for directed verdict.
And so what I'm going to show is the evidence in this case.
I draw all inferences and conclusions in the light most favorable to the non-moving party.
Exactly, and this is a motion. This isn't a properly directed verdict application anyway. It's not a trial. You need to hear the entire case, but when I got to the end of the case, what I'm going to show you
I thought you rested your case.
Yeah, but I'm saying when you hear her case, there's going to be more coming out that's going to implicate them in the fraud and the sanctions.
So I find, based on what I've heard so far, in the light most favorable to the non-moving party, a reasonable fact finder could find that you've established your claim, and I'm going to respectfully deny the motion for directed verdict. So let me turn now to Ms. Garcia to call any witnesses or evidence that she would like to produce.
Sorry, Your Honor. I thought you said after this witness that you were calling a lunch break.
I would like to get this case concluded today. We've really spent a lot of time. So you have a witness, I think that's on Zoom. I can give you a short break, but we're going to conclude today. So you have Mr. Stansberry, I think you said you were going to call, and who else?
I have myself
And yourself?
and potentially Miss Bernstein.
Okay.
And now that he's done that to Mr. Bernstein, I have to see if I can find him.
He's done what, Mr. Bernstein? Since
Now that he read his deposition testimony with no proper notice.
Okay. When we took a 10-minute break, you said you had perhaps one witness, Mr. Stansberry, who's on Zoom. Now you're telling me you have 4 witnesses.
Well, I'm testifying, definitely.
Okay. All right, what we'll do is, Madam Court Reporter and Madam Clerk, how long do you want for? You're in charge. 30 minutes? 10? Madam Court Reporter? All right. Why don't we'll take 20 minutes. There's snacks downstairs, I think. There's restrooms. Pick back up. All right, looks like everybody's present. So let me turn to Ms. Garcia. Who's your first witness?
Your Honor, what I'd like to do under the rule of completeness, I'd like to move in the entire deposition of Mr. Bernstein. I have a copy provided to counsel, but they need to make a copy because they'll have an extra one.
Okay. Do you have any legal objection?
You, please, the question, that's putting in clients, asking those who already knows, not already. He's already.
The rule of completeness allows if you publish a portion for them, if they wish to publish portions that provide context. So what additional portions that provide context are you seeking to admit?
The entire deposition goes into the whole theory of him supposedly manipulating and being involved to an excess of undue burden. And if you read the deposition in of itself in its completeness, you'll see that that's not true. You'll see what his actual testimony is, not just portions. And the document, the doctrine of completeness allows, if one party introduces in trial, the adverse party may require the introduction of the other parts of any other writing or recorded statements which ought and fair to be considered. And it ensures that the judge or the jury, the finder of fact, is to view the incomplete statement in its full context. So you'd have to hear his deposition to have the proper full context of his testimony. It's also an explanatory evidence rule. And it allows otherwise inadmissible hearsay to be admissible under the rule, to correct any confusion or wrong impression created by the admission of the original evidence.
That's the law. These portions showing Mr. Bernstein was involved in even because he was saying, and that he was stealing her counsel is out. Anything that she wants to read, introduce, and in any way communicate those topics, I'd be objective.
Let's see.
She clearly has a right. She has somewhere where this, someone can show. By all means, maybe she can read any piece.
Well, I don't think she's going to read it. I think she's going to submit it to the court out loud.
Yeah, but I don't think that's permissible.
It is one Federal Rule 109.
That's not the rule of completeness. The rule of completeness
Deals with what I just said. That's-
it would deal with an otherwise inadmissible hearsay statement, such as her offering her own client's statement if it needs to be provided to give context.
It promotes the transparency since only one part of the statement was shown. It prevents you from having a biased view of the entire situation. It allows a level playing field. It ensures both sides have an equal opportunity to present their case.
Over the plaintiff's objection, I will receive it as what defense exhibit number 27. The entire transcript as according to the rule of completeness. 90.108.
2 claps for the judge. My whole statement. That just is little clips.
I can provide one to the court.
And
I don't
think
have a certified copy.
You can print out a copy. Right?
if you email it to me, I can get it printed out. If you email it to the CAT,
I have a procedural question, Your Honor. Since I plan on testifying and I need to refer to the different exhibits while I'm testifying to either refresh my recollection or to talk about my mental process, do I sit in the witness stand with my exhibits or? Because I'm not sure, you know. Or do I sit at the table or stand
it's
here?
for you to sit at the table as long as you're by a microphone so that we can pick you up. Because I'm not going to be able to, I'll probably be able to see you at the table better than I can see you.
Right. I could stand here too if you like, Your Honor, it's up to you.
You could be seated so you can go through your.
Okay, so
so apply.
I call my first witness myself, Your Honor.
Would you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
All right, you can put your hand down now. Go ahead, Ms. Garcia.
Good afternoon.
That means.
My name is Inger Garcia. I've been an attorney since 1991 in Georgia. In Florida, I was licensed in 97. However, in 1989, I worked under Judge Kastradakis at the prosecutor's office for Janet Reno in an internship and for chief judges. I've been litigating since the late 80s. I am aware of the rules and the procedures in court, as well as testimony, impeachment, and honesty and integrity to the court.
Question she asked, the question, the answers, actually. Well,
I'm
just interrupt and object. It's
I-
all been-
I think asking her to ask herself questions is it's not going to work. So yes, just interrupt if you believe that she's providing testimony that is not permissible under the evidence code.
Okay, Your Honor. This is a case of a fairly long-term foreclosure between the Sahms and the Bernsteins and BFR, the company. I came into this case in January of 2023 to file a motion, a 1.540 motion, and a motion to continue a sale. Prior to that, there had been a bankruptcy filed by BFR, involuntary bankruptcy filed in Palm Beach County. You have the retainer agreement from Mr. Schreiberg in evidence, Your Honor, as Defense Exhibit 13. I attended those court hearings. First of all, I analyzed this case and determined very quickly during many, many foreclosure cases, because I've done a lot of foreclosure litigation over the years in real estate. I've been involved in real estate since I'm 18 years old. Worked for John Ritter as a real estate attorney back in the late 80s. I'm very familiar with foreclosures and the requirements and a proper protocol for a plaintiff to get a final judgment. I'm also fully aware of when someone dies, you have
So a witness, no matter how qualified or skilled, is not able to testify as to legal conclusions. That's for me to decide. So
okay, so I'm here to testify to my mental impressions that I've gained as a litigator in this case by observing the bankruptcy in the initial involuntary bankruptcy over the summer of 2022 and over the course of representing the Bernsteins in the foreclosure case. And then subsequently, as of August 2023, representing Patty Sahm Jr. based on an injunction that was filed against her in the mental health and guardianship cases. So I've been able to have, and then I also was at the hearing in April or May, April of 2023, where Mr. Bernstein had filed individual bankruptcy. And I was at that hearing. So I've been able to observe by analyzing all the cases as a united. There's a trust case
Your Honor, also where the funds are being held, $277,000 has been held to pay this settlement, to pay for this foreclosure. There's a court order, that money's been available.
She's testifying, she's providing it, right?
Yes.
Oh.
I'm testifying from my knowledge and opinion as the attorney. I can move the court order in, Your Honor, from that case. We can do judicial notice. The Shirley Bernstein Trust case, I can give the citations. I'd be happy to do.
Right.
There's the court order reserving funds. The court order specifically states that the funds that are in the trust, the court registry, are to be used to satisfy the mortgage.
And do you have a copy of that order?
I don't, but I can pull it off the docket, Your Honor, and do judicial notice.
Are you objecting to the judicial notice of the order?
See it on my
Okay. I'm overruling the objection.
Actually, Mr. Sweetapple is involved in that case because he filed a motion recently to release those funds for other purposes. For the purposes. So he is aware of the case and he is aware of the court order. And there have been emails back and forth. But by looking at the overall picture, Your Honor, what I gleaned, my knowledge, is that when I came into this foreclosure case in January of 2023, I saw massive legal, technical, and fraud issues on the court. I brought it up to Judge Bell, who came in. KATHRYN resigned, I believe, like the day before the hearing. So Judge Bell came in for a short time frame, continued the hearing, continued the sale from January 2023 to April of 2023. And then at that point, then BFR filed, there was an involuntary bankruptcy filed. When it got converted to Chapter 7, the clients couldn't afford an attorney, so they just let it get dismissed, and then sanctions were moved for. But in that court, again, I determined by looking at the retainer as an evidence and looking at the notice of appearance that was filed by Mr. Schreiberg for a dead man, and I brought it up to the federal court and said, Judge, they're filing still for Walter Sahm, who's dead, and you have his birth certificate, his death certificate in the record, stipulated to as exhibit.
I'll stipulate it as
I think it was 7.
He died in 2021. I believe January 2021. And after Mr. Sahm passed away, there was no substitution of counsel of the estate. And also in evidence is proof that the estate, when they did their notice of inventory, they did not list this.
I guess the problem that I'm having is I don't understand why, if we keep wanting to talk about the 1.540 motion, we haven't done both of them at the same time.
Your Honor, I think we need to all the respect for the notice. There's never notice on wherever never said anything, just a full conduct.
Okay, but that's not a legal objection to her testimony right now. My question is,
it goes-
how is the 1.540 issues relevant?
I'm not.
No, but how is it relevant to what we're here for?
It's relevant to here because I believe that when they're accusing me and Mrs. Patwell, my clients, of fraud on the court, there's a reason this case was settled. And I'm trying to explain the mental process and the reason legally of why observing the different inconsistent behaviors and inconsistent filings in court orders that are not accurate, that are inconsistent with transcripts and findings.
I asked the question, so I'd like, she's answering my question.
It's relevant to the issue of this. What is the fairness to Patricia Sahm for settling a case for an amount less than a final judgment? And to make a decision in settlement
what you do is you look at the facts of the case, and you look at the potential defenses and the costs and the expenses, and you look at what is pending and what has happened where, so you know. So I'm trying to explain to the court, my mental process and what I see is the reason this case was settled. So the court understands this wasn't a rush to go settle a case for an amount that wasn't fair and reasonable and understandable based on the affidavits of summary judgment, based on the final judgment, based on the pending pleadings, based on the different frauds that I can explain to the court.
But how is your intent as to why you wanted to settle the case relevant to the issue of whether or not the settlement agreement should stand?
One of the factors to determine if you're going to set aside a settlement, you have to find by clear and convincing evidence there was undue influence or fraud. So I'm explaining to the court why there was no undue influence or fraud by the facts of the case, and explaining to the court that the actual behavior of Ms. Sahm's attorneys, the different attorneys in the different courts with the inconsistent misrepresentations, is one of the reasons why this case was settled by Ms. Patwell and I, is that we saw the risk as far as the damage and the costs and expenses, and it wasn't worth it to either client to not resolve it how they resolved it.
Are you trying to testify as to why Ms. Patwell decided to settle the case?
I can tell you based on my conversations with her of why we both agreed that this was a fair and reasonable settlement and it was proper.
So how is that not hearsay, I guess?
Because I'm testifying to my mental impressions of based on conversations.
We're in a loop. I understand that the defendants want to settle the case. Obviously, the defendants want to settle the case. But the issue really for the court is whether or not the settlement agreement that the plaintiff, Ms. Sahm, ended up signing with Ms. Patwell's assistance, with the defendant's assistance, whoever, whether or not there's undue influence, fraud, coercion, anything like that. How is your intent relevant to that?
I believe that the actions of Mrs. Patwell and I, and prior to her, Mr. Morgenstein, who was retained specifically to settle the case, independent of me and independent of anyone else, prior to any thought process of a guardianship appearing in April 13th. He was retained by Mrs. Sahm independent. I've never met Mr. Weinstein. He's not a friend of Kevin's. The representations are that we somehow or another brought in this attorney to nefariously settle a case. She independently found Mr. Weinstein, entered into an agreement with him on April 12th. And my testimony from personal knowledge and from reviewing the different documents and speaking to my clients is that he left quickly after Mr. SWEETAPPLE would not cooperate with the substitution, and because a phone call was made to him claiming to be Ms. Sahm to terminate him when that's not who made the phone call. So he was run off, just like Ms. Patwell was run off.
What is your basis for that knowledge? Is it not hearsay? Were you there for the phone call? Did you hear the phone call?
I did not hear the phone call, but from speaking to Mr. Weinstein and speaking to
Somebody told you
Amber.
something out of court and you want me to consider it for the truth of the matter asserted. That is hearsay.
Not necessarily, Your Honor. I want you to consider it to understand our frame of mind that we were attempting to do this in good faith. We weren't nefariously running to settle a case after guardianship was filed. There was prior settlement negotiations, which does go to the elements and the facts of the case.
So, then why don't you focus on what role you have taken as opposed to what you've heard other people do, or what you believe Ms. Patwell wanted to do, or what conversations Ms. Patwell had with you, as opposed to things that are clearly hearsay.
Okay? The role I took was when I was informed that there was Mr. Weinstein was going to be the attorney, I contacted him and asked him if he was going to be jumping in as her attorney. And he said yes. And the day before the bankruptcy hearing, he couldn't come to the bankruptcy hearing to tell the bankruptcy court that Ms. Sahm had hired him to settle. So I told the bankruptcy court, as an officer of the court that day in April of 2023, that Mr. Weinstein had been hired, and that the power of attorney of which the claim in his case was made was revoked. And I told the court, I said, and I had the transcript, and I told the court, I said, Judge, I don't believe that they know, Mr. Schreiber knows that the power of attorney was revoked, but he's traveling. If you look at his first retainer, that's in evidence. That was in 2022, where he said he represented the estate, which now we know has no rights, which I was misled the entire time about the estate having rights. That's why I negotiated with Mr. John Raymond for months, for the whole month of March. So they filed claims in the bankruptcy court based on a power of attorney that didn't exist and based on a claim for a party that doesn't have any rights, which he admitted over and over again in this case. And in emails, that the estate of Walter Sahm never substituted in, the estate of Walter Sahm was never a creditor, but they're going into federal court and representing that the estate has rights and securing judgments against my clients and securing orders that are simply not based on truth.
In the name of the estate. But that was good.
The only ones that can give here standard of law in bankruptcy court are in the first instance, that comes from the court, and in the second instance, this proceeding. So I sit here to who's respond to her view of what she did. In fact, she's involved in, when did she learn that the committee had found, and so this was, that Mrs. Sahm was incompetent? What did you do after that? Why didn't you contact me when I was counsel of record? Why didn't you listen to the substitute?
Okay, we've gone beyond legal objection. I'm sustaining the objection. If you want to argue the case, you could argue the case. If you want to testify to facts that you want me to consider, subject to cross-examination, stick to the facts that you want me to consider.
So I will testify that, Your Honor, that in the month of March 2023, I was negotiating a settlement of this matter with John Raymond, who represents the estate, and represents Joanne Sahm as the trustee. The trustee is the one that owns most of the assets and controls the assets. During that time frame, when we were negotiating, I was led to believe that the estate had rights and that Ms. Sahm was incapacitated because Joanne Sahm had testified in bankruptcy court in 2022 that she was representing her mom under a power of attorney under a pre-need guardian. Her mother had mild cognitive issues and she had been asked by her dad to handle the financial affairs. So under the belief of filings in federal court by an estate that really had no rights and by Patricia Sahm Sr., who had no idea that her daughter was signing her name on retainers and hiring lawyers in court, I began negotiating with the parties that appeared to be the correct parties, which was the estate, and Patricia Sahm under a power of attorney. So at the time, I asked numerous questions, and it's in my email that's in evidence.
Can I ask a question?
Mm-hmm.
Was it Patricia Sahm represented by counsel? Why were you negotiating with her directly?
I wasn't. I was negotiating with John Raymond directly, but he represents, his law firm, Nelson Mullen, represents Joanna Sahm. And Joanna Sahm is the only person who really has been participating in this. Patricia Sahm has had nothing to do with the case.
But didn't Mr. Sweetapple represent Patricia Sahm throughout this proceeding? I'm not talking about the bankruptcy proceeding. Wasn't she representing Patricia Sahm? And then good morning, Ms. Garcia. Good morning, Ms. Burns. attorneys on Zoom that need to enter an appearance? No? Okay. All right, so we had begun taking evidence on Mr. Sweetapple's motion, and we bifurcated Miss Garcia's motion. Then we ran out of time. We tried to call up a case for, I think, Hurricane Milton. Tried to call up a case for Hurricane Helene. And now we're here for the conclusion of the presentation of evidence on the two matters. I think when we broke, we were in the middle of Mr. Sweetapple's direct examination. So Mr. Sweetapple, do you have any additional witnesses or evidence that you'd like to present?
Yes. I showed Ms. Garcia a number of documents, most of which are for judicial notice, because it's my position in this case it's ultimately a matter of law. I did put in reports from the examining committee, but the court was concerned about them being hearsay. And even though I believe this is a collateral estoppel argument and that Judge Birkin clearly ruled that he relied on those, the court indicated, well, the date could be hearsay. So I indicated that I call Dr. Bloom and Dr. Cheshire. They're going to be 15 minutes each, half an hour each, but they're not available until 1:30 and 2.
Okay.
So after I put in these exhibits, which I believe Ms. Garcia has no objection to, I won't have any witnesses to call until then, and she can proceed.
Okay.
All right. So if I may, I'm going to move in. And what exhibit number are we in? Thank you. And I can hand these to your clerk for the court.
I was showing Ms. Garcia first.
Yes. So I'm going to just hand it to clerk tomorrow.
Let me see if Ms. Garcia has an objection. So that's
For identification.
sure. So you said plaintiff's exhibit number 5. What is that document?
This is an email from Ms. Garcia to Mr. Raymond and a copy of a settlement agreement that she transmitted to him prior to the one that was executed in this case.
Ms. Garcia, do you have any legal objection to plaintiff's exhibit number 5?
I have the objection that it's redacted first page, and I guess for completeness, I have my chain of emails I would move in, I guess without objection. But also, he's got an attachment here, but I don't see an attachment referred to in emails. That's it.
Okay, so I can tell the court that this was transmitted to me by my client, and I responded to my client. So this redaction is all communication with my client. If she wants to put that in for the court to review in camera, I have no problem, but I'm not waiving the privilege by adding her email to Mr. Raymond and the document sent to Mr. Raymond that was forwarded to me by my client, and then I responded to my client. That's the only redaction, and you'll see that if you see her. I don't think she does that.
Do you have an objection to the exhibit?
No, Your Honor.
Okay. Then I will receive it into evidence without objection as plaintiff's exhibit 5.
Under number 6 is an order from the bankruptcy court dated April 14, 2023, which is 3 days before the filing of the petition. I'm asking the court to take judicial notice of that. Of the sanction finding. Part of my motion for sanctions.
Is there any legal objection to exhibit number 6?
Your Honor, he did not file a proper timely motion for judicial notice, so I object on that basis.
How are you procedurally prejudiced by his introduction of this?
Procedurally, Your Honor?
Yes, ma'am.
I mean, I can say I've seen it before, Your Honor, so.
She was a party, she's filed this proceeding, Your Honor, and was to
I believe this was
counsel.
attached to motion originally, so I hear that your objection that you weren't given proper notice, and I'm asking procedurally, how are you prejudiced by the lack of proper notice?
First of all, I don't think it's on his original exhibit list, and you limited us to our original exhibit list. Unless there was documents discovered that I was produced to him during depositions. If I produced many documents to him during deposition, we tend to use. Secondly, had I known he was going to be moving this in today, I would have called the attorney who drafted this order, because
Your Honor, this is Exhibit J to our motion to strike that you're hearing. This has been,
This is an order signed by a judge, is it not?
this was signed by the bankruptcy
Mr.
court.
Sweetapple, Ms. Garcia is
Yes,
articulating to me her procedural prejudice, so.
yeah, it is signed by the judge, Your Honor, and it will be taken up in that court, fraud. So, this is how he wants today, and we'll deal with it there.
All right, then I'm gonna receive Exhibit 6 over objection as plaintiff's exhibit number 6.
Number 7, Your Honor, is the request for judicial notice. I filed in this case file, and Ms. Garcia was served with this, I believe, April 18th, 2023. Mentioned case.
That's exhibit number 7.
You have a copy, sir?
Ms. Garcia, what is your position with respect to plaintiff's exhibit number 7?
No objection.
All right, I will receive this into evidence as plaintiff's exhibit number 7.
Exhibit 8, Your Honor, is the objection to the examining committee filed by Amber Patwell as counsel for Patricia Sahm in case number 50-2023. Some of these that have mental health may have been filed under seal, so they'll have to be worked out. In the underlying case.
What's your position, Ms. Garcia, with, I believe, plaintiff's exhibit number 8?
No objection.
It'll be received into evidence without objection as plaintiff's exhibit number 8.
And then, Your Honor, I have Ms. Garcia's appearance in the underlying case where Judge Burton issued his order, which I'm asking.
Ms. Garcia, what's your position with respect to plaintiff's exhibit number 9?
Same objection to the record, Your Honor, that he didn't properly file for the judicial notice.
I thought that at the
There's no objection.
okay, so there's no object. If there's no objection, then I'll receive it into evidence without objection. But I thought that initially there was a request for the court to take judicial notice of the entire mental health
Yes.
guardianship court file
I believe
at the
so, Your Honor.
first hearing in August. So I don't find that you weren't given proper notice, but there's no objection. So I'll receive it into evidence as 9.
You've been at the.
And Your Honor, I did put in Judge Burton's order
9, that was 9. 8 was the lack of it was the objection to the examining committee report.
Okay, that's 8.
Yes, ma'am.
Your Honor, I already put in Judge Burton's order determining incapacity, but I did not put in his order appointing limited guardian of the person and property entered contemporaneously. So I'm moving with the court to take judicial notice of that order as well.
What's the date of that order?
It is June, I think 22nd. June 27th, 2023.
Ms. Garcia, what's your position with respect to?
No objection.
I will receive it into evidence without objection as plaintiff's exhibit number 10.
And lastly, Your Honor, is an order granting final injunction for protection against exploitation of a vulnerable adult. By Judge Burton. It is dated It's dated September 22, 2023, Your Honor.
All right. Ms. Garcia,
Objection on this one to relevance.
what is the relevance, Mr. SWEETAPPLE?
Findings in this order that Judge Burton made regarding, and I can read to the respondent, who is the younger sister, Patricia Sahm Jr. This is on page 414. The respondent further testified that in March of 2023, a female notary arrived at the residence then occupied by respondent and the vulnerable adult. Although the respondent suspected that the Bernstein family, with whom the vulnerable adult is currently litigating against, or Kevin Hall, an attorney involved in that litigation, sent the notary to the residence, the respondent claims that she took no action while the notary notarized the vulnerable adult's signature on documents that revoked the power of attorney in favor of the vulnerable adult's then acting agent and trustee, JOANNA. So this relates specifically to conduct that occurred at the time of the guardianship that this court is reviewing. And even though there is a legal argument being made as to why, or as on a matter of collateral estoppel has to find incapacity, I'm also making a record factually through the experts and the testimony to show the improper conduct, because I have asked for sanctions against Ms. Garcia, including for her client's conduct with her below.
All right, anything further, Ms. Garcia?
Again, objection to relevance, time frame 9/22/23 after the fact. This is a hearing that was not concluded. I'll testify, I guess, to fraud being perpetrated today, and I'll deal with any other courts.
What? I'm sorry, you handed me a 14-page document, I think. Is this a permanent final injunction, or is it time limited?
Pardon?
Is this a permanent final? I apologize.
This is an order that has not been appealed or vacated of Judge Burton.
No, but some injunctions are safe for a period of 6 months or 8 months. Is this?
It was an agreed final injunction that the court made no findings, and they put it in the order anyway. I have the transcript, I'll deal with it with the other judge now that they're using it here in front of you.
All right, I'm going to receive it in evidence over objection, subject, of course, to Ms. Garcia explaining why it's not relevant to the court's consideration, ultimate consideration. For the purposes of the hearing, I will admit it into evidence, and you can tell me why I shouldn't give it in.
But you're going to take judicial notice of it?
Yes, I'm admitting it into evidence over their objection, but she's certainly free to tell me why it should not bear in my decision making.
And other than calling Dr. Bloom and Dr. Cheshire, I don't anticipate any other witness unless there's some rebuttal necessary.
And you said Dr. Bloom and Dr. Cheshire would testify at
1:30 and 2, I have them stand by on Zoom.
Okay.
I tried to get them this morning and I couldn't.
That's okay. All right, Ms. Garcia, with respect to your motions, do you have any witnesses or evidence that you'd like to admit?
Evidence? Yes, Your Honor.
Or witnesses?
I'm sorry?
Or witnesses, either testimony or evidence that you'd like to submit?
Yes, Your Honor, but I have an issue with me having to try my case in the middle of his case. His witnesses should be here timely. It was set for 11. He told us to be here, and I object to him calling witnesses at 1:30 and 1:15. It's just not the way the court operates, that I have to start my case in the middle of his case, because I'm going to move for a directed verdict.
Well, I can take a recess I haven't had a chance to review all the documents that have just been judicially noticed. If you'd like for me to step off the bench and you can wait here while I read the documents.
I'd like to also, I guess I can go over with him my exhibits also.
Why don't you do that? Because it just seems like it's a better use of everybody's time. I'm not prejudicing you from moving for a directed verdict. I'm just trying to be economical with everybody's time.
I understand, Your Honor.
So,
That's why I
It's quiet.
So do you want to show Mr. Sweetapple? You want to take a couple moments to show Mr. Sweetapple your exhibit? I'll step off the bench. You show him your exhibits. I'll take some of these and start reading them, and then you can come get me when you're ready.
Okay.
All right.
I don't know if you can put any line. Okay.
What? What? I don't know. Recess. Okay, bye. Okay, bye. Recording. Okay.
Thank you.
Hello. Something about evidence. Something about evidence. I don't know. Oh, we'll see what happens. Okay. Okay.
Friends.
You mean like written down?
Like they have a.
Sometimes, but actually I was a supervisor for 6 years with Buzz. And I went to Henry vocation. On my job though.
It's statement Waterford.
Yeah.
Cook well done extra dressing. Yeah.
Report's back in session.
You all be seated. Right, Ms. Garcia is present, Madam Court Reporter is present, Mr. SWEETAPPLE is present. Have you all gotten a chance to go over Ms. Garcia's evidence?
Yeah.
All right. Are there any agreements to any of the evidence?
Limited.
Okay, let me see what Ms. Garcia has to present. Sure.
Authorization or identification is a death certificate with the law of Sahm.
Okay. Any legal objection?
Didn't give it up. This, no issue is this, but it's totally relevant.
Well, it might not be relevant to your motion, but is Ms. Garcia has a motion to
Yeah, my motion is not separate today, Your Honor, just the balance of this trial. I
okay.
think it had been determined that if and when you rule on the settlement, then I would go ahead and do my discovery and set my 1.540, 1.340.
So what is the relevance of this to?
The relevance to this is that you're going to see the orders and the pleadings that the gentleman died in 2021, and they continued to file pleadings in his name through 2024 without telling this court. They got final judgments. They go to the bankruptcy court claiming there's an estate issue, but then they had filed in his name there, and my testimony will explain the relevance of his date of death and what has happened since. It's very relevant to our defense.
All right. So I'll receive this into evidence over objection as defense exhibit. Is it 1 or 7? 7. Defense exhibit number 7.
No, that was for identification. And then they would do it, they did numbers. But it has defendant on. H is 7.
Honor, I noticed that you have a warning, no recording. I just want to make sure that the people on Zoom have been alerted that they should not be recording this. I see Mr. Hall and others on Zoom.
Right. So there's only one record that can be kept of a proceeding, and that is the court reporter's record. So any recording is not prohibited. It is prohibited. It's not the official court recording. That's by order of the Chief Judge and by order of me. What's next, Ms. Garcia?
Okay. If I may approach.
Sure.
Final judgment in this case?
Thank you. Any legal objection?
No, Your Honor.
I will receive it into evidence without objection as Defense Exhibit 8.
This one is J. The judicial notice, this was filed in this case, January 2nd, 2023 by me. I made my initial appearance.
Just note my objection to relevance, Judge. It has nothing to do with the competency issue and the brought on the court issue.
Grace, what's the relevance of your motion?
The relevance of my motion, Your Honor, is I started from when I came in the case from day one, disclosing to the court all the issues with the fraud and filing for dead people and filing cases, the estate, the bankruptcy cases for an estate that had no rights, filing for Patricia Sahm.
Your Honor, the 1540 motion is not being heard today.
That's what my confusion is. It seems, I'm not saying that this isn't relevant to your 1540 motion, but I'm trying to figure out what the relevance is, the motion that we're here for.
The relevance is, Your Honor, that they're coming in here with unclean hands. Like, for instance, on page 6, paragraph 11, Mr. Sweetapple continued to represent Walter Sahm after his death without informing the court. And even when there was a suggestion of death filed, he continued to file pleadings in the name of Walter Sahm. And a final judgment entered in the name of Walter Sahm, which was what was settled. So it's going to show that from day one in this case, there's been issues as far as the final judgment, the amount, the outstanding issues of 1.54 and 1.30 do affect the reasonableness of the settlement. So the court goes through this, the elements where you have whether or not they can even prove incapacitation at the time or not, since it was before the finding of the court. First of all, threshold issue, and then next you have the issues that he's claiming: undue influence, fraud, and I'm not sure what else he's claimed.
Okay. I'm going to receive it into evidence over objection as Plaintiff's Exhibit 9.
Next one is K, Your Honor.
I think you can just tell the court whether I objected to it or not.
This one you rejected to relevance, I believe.
Well, this is where this was hearsay. You're trying to, first of all, any communications from Mr. Raymond, I would require testimony to authenticate some form, and then there's an affidavit.
Oh, sorry, I'm so sorry.
An affidavit from a Mr.
We need to identify what it is for the record, and then
The email chain I produced to counsel during the deposition when we were ordered to waive privilege or to appear and take privilege. And I produced a record, and this goes to the settlement negotiations between me, Mr. Raymond, and Mr. Sweetapple, and dealing in March of 2023 during a relevant time frame as to the capacity and the negotiations between the lawyers. And it's clearly when I'm asking questions of the attorneys and they're responding, this is the attorney for the estate. And that's relevant to the issues of filing the bankruptcy, claiming estate rights, not substituting the estate.
okay. So
Yeah.
your objection to it is hearsay.
Well, in terms of, find an affidavit by William Stanberry, she showed me an affidavit she wanted to put in, and,
I don't have an
I didn't
affidavit.
attach that.
okay, so yeah, I'm
Objected.
you sure you're not gonna move, you're gonna agree with me that doesn't come in?
No, but I'm not doing it here, I'll do it separately. You told me I needed to bring.
All I have is an email.
All right, well, first of all, there's representation that's sent to me, which is inaccurate. Second of all, you're gonna learn that she sent numerous emails to a different email address than my email, repeatedly in March, and never included me on any of these, despite Mr. Raymond saying, include Mr. SWEETAPPLE's in charge. He's handling this, not me. So if we get into these communications, I'm gonna have to, for completeness, cross-examine her on the whole episode. And so I would object to this unless she comes in and testifies, authenticate, and I can ask her for completeness about other emails and what she did.
So your objection is it's not authenticated?
Yes, she would have to come in and testify. Mr. Raymond's not here, so she'd have to say, Mr. Raymond sent this to me, I received it, and then I'm gonna ask her about other emails.
Okay. All right, are you in a position to do that?
I can testify to receiving the emails.
All right, so then I'll have it marked for identification purposes, subject to it being authenticated. There's no other objection.
Yeah, I'm not calling her, but I anticipate cross-examining her based on.
I wasn't sure if there was it's highlighted indicating that the part that the court wants, she wants the court to consider is Mr. Raymond's statement, which seems to me to be hearsay, but if there's not an objection to that, then
Well, that's,
then
it
it's just
is,
authenticity. Let it get authentic.
well, I'm gonna object on hearsay, Judge. I thought we had her statements here as well, so I will object to hearsay on anything just from Mr. Raymond.
Ms. Garcia, how is Mr. Raymond's statement not hearsay?
This email is our communication in relation to the settlement, and it's relevant. And when I asked him questions, he responded.
Right. So hearsay is a statement made out of court
This is-
for the truth of the matter that's asserted. So how is it not hearsay?
It's an exception under the business rule. This is a communication for my law firm. It's a business record. This was received by me, and I can authenticate this as a business record.
Okay. And how is Mr. Raymond's statement to you not hearsay?
I guess I can test. I guess I. Can I have 1 moment, Mayor?
Sure.
I have no objection to her portion of emails coming in, as long as she authenticates them and I have a chance to cross-examine her and bring in her other communications. To the extent she's just trying to put in Mr. Raymond's communications.
I just, that's what I thought. I only thought that because it's highlighted in orange, but if that's
I don't
not,
have a highlighted copy.
that's not what you're seeking to do, then
She didn't give me the copy. Highlighted.
After 2 p.m. today at any time?
this is what was handed.
Give me the best time for you. The hearing's in the middle of it, I'm taping it. What's the best time for you?
Yeah, I didn't, that wasn't, I was looking at.
Here.
I didn't.
Give you one. So when he has, where it's highlighted.
2:30?
It's okay. I'm not trying to create issues. I just,
Okay, thanks, love you.
For one thing, Your Honor, there is an exception under
You're gonna
party
read your
admission.
affidavit and you might have to respond to it.
Because this is where the other attorneys that I was
They haven't
negotiating
sent
with in
you
this
one.
case, who represent the parties, are
Yeah,
informing
right.
me
Otherwise, somebody
that
will.
Ms. Sahm wasn't under guardianship and didn't need a guardian in March.
Right.
So that goes
Okay.
to my
Let me
mental
try
impression
to-
of what was her status. And I will testify to
Yep.
different conversations and different mental impressions that I had, and that
You
Pat
can
will have
log
based on our
into the
conversation.
Zoom I sent you the
I'll have it marked for
information
identification
this
subject to being authenticated.
morning on your
That
check.
does sound like an exception to hearsay.
And
Okay.
just so we're clear, I'm also objecting to relevance from this statement.
No,
And
I know,
on March,
I
when
know,
we're on
I
the
know,
subject
I know.
of admissions by
I know, okay. Let me get
parties,
it.
representatives of parties, I am gonna be one of the exhibits I provided to the court because Ms. Garcia just provided me with the May settlement agreement she forwarded to Mr. Raymond that is signed by her clients, where their repeated representation that Mrs. Sahm is incapacitated. That's in May. All right, this is in March.
Okay.
So just so the court, for relevance and context, yeah, I'll be moving, we've already admitted that in evidence, but I'm going to ask the court to note that that is an admission of Ms. Garcia as the representative and the parties.
Okay.
I have just one moment.
Of course.
The next one, Your Honor, is marked as, for identification exhibit L. You have to deal with the gender.
All right, what's the plaintiff's position?
Objected, it's hearsay, Judge.
Ms. Garcia?
I can, call the witness.
I'll sustain the objection as to hearsay, but I'll have it marked for identification as L.
And note my objection also to relevance that this witness doesn't have any testimony since March of 2022. It's not going to be relevant today.
I've found that it's hearsay.
Just saying, if we get, when that witness comes in, I'm just reviewing that date of this.
The next one, Your Honor, is N. Left letter, signed by both parties, deceased Mr. Sahm and Mrs. Sahm as the trustee.
This is undated and hearsay, Your Honor.
It's a statement of a party opponent. It's also Mr. Sahm is deceased. It's a statement by him, which is the exception to the hearsay rule.
Where is that in the hearsay exception? Statement of a deceased person. Isn't it a statement of a person upon impending knowledge of death?
Your Honor, also relevance, it says a phone call October 11, 2019.
Isn't this prior to the final judgment?
Well, it's prior to the lawsuit being filed.
This goes to the relevance is that it goes to the long-term negotiations because there's allegations that basically once we found out that there were some committee reports out there, that we rushed to do a settlement, and this shows the court by statements by both parties that this has been going on for years. And it talks about the amount of $200,000 was a reasonable amount at the time, where they were willing to accept.
Right. I find that this is hearsay, so without an exception. So I'm going to sustain the objection unless it can be authenticated some other way. I don't see necessarily how it's relevant, but it is hearsay.
I could authenticate it by the receiver of the letter who's here. I can testify, Your Honor, so. It's marked as Your Honor. It's a retainer by a trade union. They rolled out in 2023.
Hearsay, Your Honor. I would note, though, it is telling how the defendants have communications between an alleged attorney for Mrs. Sahm. This is a privileged document, and the fact they even have it is consistent with my theory of the case.
I'm going to overrule the objection. This appears to be a legal document, which it's words of operative legal effect, so that is an exception. So, what were we at? Number 10. We received an evidence over objection as a good number 10.
Honor, just if the court, if you'll note, I don't see page 2. I don't see it signed by Mr. Weinstein.
It appears to be signed by the plaintiff.
Yeah, but we don't know if it's paid or anything about it.
And you'll be free to argue that to me
Okay.
as to why I should or should not consider it, but it appears that it's authentic and it appears that it would be admissible in the evidence. I'm going to receive it for whatever its evidentiary value is.
Your Honor, on the is email. From Morgan Weinstein to Mr. Sweetapple. This deals with their communications in April 13th, 2023, when Mr. Weinstein was attempting to substitute in as the attorney in this case based on his retainer with the client.
All right, what's the plaintiff's position?
That is from Kevin Hall.
This was
You're referring to just the Morgan Weinstein to me?
This was produced during a deposition pursuant to your court
You're
order.
talking about this section right here. Although Mr. Sahm does not have an email address but responds to regard Patty's email account. I've copied that account here. Mr. Sweetapple was asking you to email back to authorize the change in representation from this firm. So
Is there an objection to that?
it's just hearsay. I don't think it's complete either. I presume there's a response somewhere or follow up on any of this. Not relevant. It doesn't tend to prove or disprove anything.
It is relevant. Won't let me respond.
this is hearsay from me, it's hearsay within hearsay. He's writing to Patricia Sahm, copying me saying that I have asked something to happen.
What, Ms. Garcia, what's it being offered? Is it being offered for the truth of what's being stated?
It's being offered for the fact that that this communication occurred and that Mr. Sweetapple was aware of the potential of substitution in this case on April 13th of 2023.
All right, the portion that indicates Mr. Sweetapple is asked to email back to offer as a change would be hearsay, but the fact that the communication occurred and Mr. Sweetapple's email is CC'd to the email is not hearsay. So I'll receive that portion of it in the evidence as 11. Defense exhibit number 11. Over objection.
Is there any follow-up email to this she's offering? Where that's something happened?
I don't know.
Actually, here is next email, exhibit Q for identification. Further communication. And Mr. Sweetapple and Patty Sahm Jr., she was communicating with Mr. Sweetapple to see the power of attorney because Mr. Sweetapple had asked for a copy of the revocation of power of attorney and requested that Mr. Weinstein, substitute in as her attorney.
I'm going to object to hearsay because I certainly want Patty Sahm to testify.
Garcia, what's the purpose of this email again?
The purpose of this email is to show the fact that there was communication and Mr. Sweetapple had knowledge that he was requested to substitute out and allow Mr. Weinstein to substitute in. And Mr. Sweetapple had asked for a copy of the power of attorney and it was the revocation of power of attorney was provided to him at that time, 4 days before the guardianship was filed.
There's no attachment to this. It says, I have attached my mom's revocation. And there's nothing attached to this email.
The revocation is already in evidence, Your Honor, as composite exhibit 1.
I'm going to receive this item of evidence I'm going to receive this exhibit into evidence over objection for the reasons stated by Ms. Garcia as defense exhibit number 12.
No, is that one? Q. I apologize. Q, okay. So 11 was that one, that was Q, okay. Then, R. We're going to mark this defense exhibit R. It's further email communication in relation to the same time frame. This was April 15, 2023, 2 days later, where
This is all hearsay from the daughter, who I believe is on house arrest still, but available by Zoom.
okay, she's off for 2 days.
Pardon?
She's off in 2 days.
You can call her by Zoom. I've been trying to unsuccessfully get her depot scheduled for months.
Well, not true. So, Your Honor, this goes again to the fact that at this time,
The hearsay is the objection.
Hang on, I need you to not all argue with each other. I need you to state your position so that I can make a ruling. So, your objection is that it's hearsay. Ms. Garcia, how is it not hearsay? This communication between Mrs. Sahm and Morgan Weinstein, who's not Mr. Sweetapple or anybody employed with Mr. Sweetapple's firm.
Well taken, Your Honor. If I want to admit it, I will call Ms. Sahm. Okay. Marked as Defense Exhibit S. I mean T, I apologize, I distracted.
Okay.
Your Honor, this is produced going to the deposition.
My objection, Your Honor, is hearsay. These are texts with Ms. Patwell, who I've also been trying to depose, who's also incarcerated. So obviously anything.
I need to know what Ms. Garcia's exhibit is, for the record, and then I'll ask you what your objection is.
So this is Exhibit S, Your Honor, and this is the messages with Morgan Weinstein and myself, because our communications and our knowledge of what was going on at this time frame when we're being accused of committing fraud, taking advantage of somebody, you ordered us to produce these communications. So I produced the relevant communications from 4/10/2023 through 4/16/23. The last one is irrelevant here. Which basically is my communications with Mr. Weinstein, which I'll be testifying to. The fact that he told me he was being retained, he was following his notice of appearance, he's the head of assigned retainer.
It's hearsay. Anything Mr. Weinstein said in these is hearsay.
And in your statements, how are they not hearsay? I mean, if you're going to testify to it, that's subject to cross-examination. I don't see how this is an exception to hearsay.
This is a business record, Your Honor. This is my communications with opposing counsel that I was ordered to produce in a deposition, which I produced in a deposition, was subject to cross-examination at the deposition.
I haven't heard that it's a business record. I mean, it may be. I haven't heard that. This is kept in a regular course of business, communications with opposing counsel, communications with my clients. In this particular document, you ordered us to produce the communications. So I did. He's had the benefit of it, has cross-examined. Just because I ordered it produced doesn't mean it's admissible into evidence. It means that perhaps he would like to admit it into evidence as a statement that you made. I don't know, which would be an exception to hearsay. But if you are asking to admit it, I need to find out how it's admissible.
And anything that's her communication, I'd want her to authenticate, but I'd be objecting anything to Mr. Weinstein.
Right.
This is an authorized admission, Your Honor. Federal Rule of Evidence 801 B2 CD. Supposedly there's a conspiracy. This would be an admission of a co-conspirator also, under this theory, under 801 D2E. Also an adopted admission.
Who's the co-conspirator?
So that would be an exception that he would seek to admit it under, unless you're conceding that you're part of the conspiracy and you're saying that you wanted to introduce your co-conspirator statement.
No.
Is that what you're?
No, I'm not saying that we are conspirators. I'm saying we've been accused of conspiracy. We've been accused of fraud.
I will reserve on ruling on it, but as of right now, it sounds like it's hearsay without an exception.
But then also, this whole thing about Mr. Weinstein is irrelevant. There's no dispute, I was never provided with a proposed substitution of any form.
It may ultimately be irrelevant,
I
but
mean, we're on a wasting time.
your witnesses aren't available till 1 o'clock.
I know, I understand, but.
At 1:30, so we have to get this. It would have been nice to have some agreements to some of this to streamline things, but there was an objection to even waiting till 1:30. So let's use our time wisely.
Here's, you, Your Honor, that's you. This is a key brief that you did from order.
I had no objection to this. It's Mr. Schraberg's fee agreement from the bankruptcy court. He represented the estate, and Patricia Sahm individually.
So you have no objection to receiving defense you into evidence.
That's correct.
Exhibit
In
13.
bankruptcy court, you're required to file your fee agreement, so there's really no privilege at this point.
Received in evidence without objection as 13, defense 13.
Exhibit V, Your Honor. That's the report of an examining committee member.
Make 2 pieces and put the salad in a bowl. Thank you.
This is the one who's going to be testifying second. I have no
And the
objection.
salad in
I'll receive it in evidence without objection as defense 14.
the salad in a bowl. Goodbye.
So that was, V, allowed as 14, Your Honor?
Yes, ma'am.
Thank you. Exhibit W?
May save some time. We're discussing, we may waive calling this witness if she's allowing this in evidence.
Okay.
That's W. Your Honor, exhibit W is a report.
This is not filed. This is.
Sugar.
Yeah, I need her to tell me what it is. You to tell me why I should or should not.
I thought she was finished.
It's okay.
And this one is being moved in for the fact that it was prepared, just like the other ones that you had allowed, that although it's hearsay, the fact that this report exists, so I can testify to the relevance of it in my testimony.
Your Honor, this is not a appointed examiner. This is somebody they went out and hired. It's not filed in the case. It wasn't part of Judge Barton's review. And it's hearsay.
It is hearsay. The other one was not objected to. This one is objected to. It's
You
hearsay.
said the doctor who they testified had a high holy day and couldn't be here. We had to continue so he could be here. So obviously there's no prejudice. They know that if they want to call Dr. Sugar, he has to be here.
Dr. Sugar's report is hearsay. Sustaining the objection.
Your Honor, I'm moving in not for the contents, but the fact that it was prepared and the date it was prepared. You had allowed the other reports, same purpose, saying it was hearsay. I'm not moving in for the contents of the report, moving in for the fact that it was prepared, when it was prepared, and the relevance, in my mind, of this report.
It's all hearsay.
No, it's not hearsay, 'cause I'm not gonna discuss the relevance of the report.
I will allow you to testify to the fact that a report was prepared, when it was prepared, and that you received it, but the substance of the report is hearsay,
Understood.
without an exception. So I'm sustaining the objection to the physical report.
But it's allowed for the fact it was prepared?
Yes, you can testify to that, yes. I think you have testified.
I think we started, Your Honor.
Yes, identification.
Okay, the next one, Your Honor, is composite exhibit Y. And it entails the promissory note in this case.
These are attached to the complaint and the court file. I have no objection. They're not relevant. I have no objection.
I'll receive them into evidence without objection as composite exhibit 15. How many composites are there? 15A and B?
Note and mortgages, amended mortgages.
So A and B. Loan mortgage. Okay, well, I'm gonna make the promissory note is 15A, and the mortgage is 15B. You're receiving evidence that.
I'm sorry, was the V, which was the Cheshire report, was that was admitted as exhibit 14?
I stipulated to that.
Right, so that's
Correct.
14?
Yes, ma'am.
They say it was fine.
This one was exhibit 15. Defense ID exhibit B, Your Honor. I believe that he agrees to the
No objection to judicial notice of this. It's in the court file in this case.
It'll be received in evidence without objection as defense exhibit 16.
So it was defense D, it was defense 16.
Yeah.
Thank you, Your Honor. Is defendants AA. And this is a state record showing that the Bernstein Family Realty LLC was active as a reinstatement on the relevant time frame, March 16, 2023.
And Your Honor, it was then dissolved administratively not long after that. And as long as I can put in that to show that it's not currently in good standing, I have no objection as long as I can put in the current document that shows the actual date of dissolution.
Any issues with that, Ms. Christie?
I'm sorry?
Any issues with what Mr. SWEETAPPLE proposes?
I have not seen what he's talking about, so that's what the public record shows. I don't have a problem with that one also coming in.
So the public
Be
record shows.
composite.
Yes, Your Honor, it's the same printout from Sundays.
So then
But-
I'll allow his in if I'll allow Ms. Garcia's. So it'll be received by stipulation as defense exhibit 17.
Yes. It's
We'll
composite,
provide that to the court, we'll print it during.
so I guess I would call composite 17, since he's gonna add the second.
He's gonna add it as plaintiff's exhibit, whatever.
stipulates this judicial notice, this is, defendant's BD, this is suggested bankruptcy filing case 4323.
Position of the defense, or the plaintiff?
No, I have no objection to the court taking justice from the court file.
And to be received in evidence of that objection as Defense Exhibit 19?
18.
A lawyer, I can only count so long.
Okay. Defense or identifications be against a judicial notice, Your Honor. This is a filing of this case, so filing the guardianship of the mental health case, my appearance for Patricia Ann Sahm Jr. dated 8/14/23.
Position of the plaintiff?
No objection.
Be received in evidence of that objection. That's 19.
19.
I'm back. 19.
It nearly does. Okay, then we have defense EB, which is a 5/22/23 judicial notice. Ms. Patwell notice of appearance in his case of May 22nd, 2023.
Position.
No objection.
Be received in evidence without objection as Defense Exhibit number 20.
Defendants EB for identification, Your Honor. The division of the counsel signed by Sahm.
This is hearsay. It wasn't, doesn't show it was filed.
I thought this was produced in our August hearing and received into evidence. Was
I
it?
believe, let me see, stipulation for substitution, yeah, it's defendants.
That was me and signed. This is Laurel Buckle.
Let me see, plaintiff, it was defendants, D, and it was admitted as exhibit 3 already, Your Honor, evidence 3.
This was already in?
Yeah.
No.
I believe, I have to compare it.
So the original exhibit that was put in as her D, as defendant's D, was an unfiled stipulation for substitution that was signed by Patty Sahm Sr., but was signed by the attorneys in this case.
That's what this is.
That's for that was for,
This is the probate court, Judge.
that's the probate court in front of you.
This is not.
This is
The MH, oh, I'm sorry, you're right, Your Honor, I
This is
apologize.
2018 CF, that's this case.
No, Your Honor, I apologize, it's the wrong, let me take that back and refresh. No, this is a stipulation for substitution of counsel in the mental health case, where, Pat Wells.
It's 2018 CA 2317. That's this case number. What you've handed me, maybe perhaps you handed me the
I
wrong
handed you
copy.
the wrong one. What is yours? The MH case? I didn't hand you that.
It says probate division on top. The one that went
I
into
think
evidence.
you have a different paper than I do, what I'm saying. I have this one. That's this. Okay.
Sorry.
That's what we-
Sorry for the end.
This is what we.
This is, yeah.
Okay. Anyway.
Now I'm gonna put it, I'm gonna have to mark it correctly.
No problem, no problem.
If she has this one's filed in the case, I have no problem with the judicial notice, but this is, she's handed me a stipulation for substitution counsel probate case, allegedly signed by Patricia Sahm and nobody else and no date.
This was EE.
So this is the stipulation in 2023 MH 1072.
Yeah. This is the one in the mental health case to show that Ms. Patlow substituted in for Laura Burkhalter. And this is the stipulation signed by the client. I think we've already moved into evidence and notice of appearance. So I guess it could have really been attached to that, but I can't separate.
Noting your objection, I'm going to receive it in evidence as defense exhibit number 21.